authoritative coverage of the state of corruption. Our special coverage of the same for today begins right now, and we shall be delving into the issues that affect you at whatever level of society you are in light of graft. Good morning and welcome to the broadcast. I'm Dan Mwangi and I hope you have a great day, a winning one. Yes, even for Manchester United fans, you can still win. And speaking of losing, yesterday it came to the fore that the country may have lost millions of shillings to Deputy Chief Justice Philomena Mwilu, who was arrested and arraigned. She is set to be before the court this morning to answer to charges preferred against her. We shall be going big, that is, on this, and I shall be doing it with an able team in various parts of the country. We shall be having Trevor Mbija at the Milimani Law Courts, where he shall be having a panel as we wait on the matter to kick off in court. Mel Miendo is also at Milimani following up on the same. The Chief Justice, David Maraga, is set to address the media and the nation at large this morning, after his deputy was arrested yesterday. Ken Mijungu will be at the Supreme Court, where he shall also seek the insight of various opinion shapers. We shall be listening to you, the Mwananchi, in various parts of the country. In Bungoma, Zacchaeus Masame shall be covering for us there. In Bita, which is in the county of Homa Bay, Bernardo Juang keeps us abreast. And in the lakeside county of Kisumu, we shall have the voices brought to us by Aoko Kusa. And in the city of champions, Eldoret, Lois Wangoi will have some guests to speak to us on the same. And we shall also look out for any more arrests in the day following the DPP Nurdin Haji's statement of the war on graft being far from over. So welcome to the broadcast. So let's cross over to Eldoret, where Lois Wangoi is standing by to give us an idea of what exactly to expect. Lois, what do we expect from that end of the country?
Good morning to you, Dan Mwangi, and of course to you, dear viewer. A very interesting day today, a day after we did witness the arrest of the DCJ, Madam Mwilu. On this particular day, we expect a number of reactions from the residents here, of course, following up with the conversation of the state of corruption here in the country. We'll be looking out for that. Later in the afternoon, of course, I will be with a number of guests here to be able to dissect on this topic of the state of corruption and to understand where exactly we are as a country, how Kenyans consuming everything that is seemingly going on in this conversation of taking Eldoret as a case study, and of course the neighboring counties. It is a conversation that is very interesting to listen to, because we understand that gone are the days where such conversation would only make headlines among the considered political elites in Nairobi, but even here in Mashinani, people are following closely and everyone is genuinely showing concern and an uptake of what these conversation or where these matters will be placing the country and indeed, of course, the county of Uasin Gishu. With me in studio will be a number of guests much later to talk into that, and of course a touch of Mwananchi. My colleague Gabriel Kudaka is holding brief about 15 minutes away from here in Eldoret town. He will be talking to Wanjiko on the ground, understanding how exactly they are consuming all this information coming in, their expectations, and if indeed they believe that the fight against corruption is indeed on the right path. Dan Mwangi.
Thank you very much, Lois Wangoi. We look forward to hearing from you and from Kudaka, from that area, from the Rift, and get a sense of what people expect and people's views about the whole state of corruption. And we've been seeing some of the leaders speaking about the same in the past few days, but this shall likely continue. But we also want to hear what the Mwananchi says, because ultimately what this means is that the Mwananchi shall be affected in one way or another. And to understand that, we shall be having these different discussions in studio and out of studio. In studio, I shall be having my guest, who is Tony Watima, who's already here, an economist, to figure out what exactly is this meaning for you in terms of your buying power, whatever it means for you as a Mwananchi when you go to buy your mboga. If you have your small business, what does this mean, the bigger picture in terms of the smaller lens? And we shall be getting to that. But now let's cross over to the county of Bungoma. We'll be crossing over to Bungoma in a bit. But before we get there, I'll just remind you, or rather bring to you the fact that we also have, in regards to looking at the economy and the aspect of corruption, the reported public procurement and loss of public funds in Kenya. There shall be an analysis. There's an ongoing analysis of the Auditor General's report that is being done by the Institute of Economic Affairs, which is having the event right now, and they shall be, looking at the different issues, the different factors that are being looked at when it comes to what has been brought up by the Auditor General's office in regards to public funds and the loss of the same. And the IEA Kenya says it has been implementing a project on civic engagement and open contracting, specifically focusing on public procurement violations highlighted by the Auditor General, that is Mr. Oko, and in his reports rather. The main objectives of the study are to, one, examine public procurement or contracting processes in Kenya and track systemic loss of public funds and generate knowledge on high-risk stages of the public procurement in Kenya. And this is going to be addressed by the CEO, that is Kwame Owino, as well as Jacqueline Kagume, who's the program officer at IEA. And we do have Victor Kiprop there, who's going to be giving us the details and a brief on the same. And we shall be crossing over there live once we get an opportunity to, because that is partly the discussion. Remember, on Wednesdays, our daytime bulletin, when we have ordinarily the NTV Today, we talk about business. And today we are going to be looking at the aspect of the economy, corruption, alongside the issues of following up the DCJ Mwilu's case and any other arrests that may be made. The DPP yesterday said that there'll be more arrests to come in different alleged scandals, and so we shall be picking up on that and bring to you the details as we get them. Now we cross over to the county of Bungoma, where Zacchaeus Mosame is standing by with just give us an idea of what is happening in Bungoma. Zacchaeus.
Thank you, Dan. As you rightfully mentioned, we are coming to you live from the heart of Bungoma town in Bungoma County. Here, as you mentioned, also the discussion about the state of corruption in the country is heightened, and residents are also, or they have also joined the conversation. And just to expound on this, we are going to be joined with a number of residents here. And one of them, gentleman, just move clear here, and then maybe you've seen the way the government has, announced the fight against corruption. And yesterday, the Deputy Chief Justice was arrested over the same allegation. Maybe what's your take on this? Do you think the government has taken the right direction in fight against corruption, or do you think it's just some sort of PR play?
My name is Leon Banda. About corruption, we support that corruption fully. Kulingana na mambo ya Mudun Haji, sisi tuko nyuma yake. Kiona mpaka imefika kwa mahakama ya juu, hiyo tunamsupport, kwa sababu ukienda kwa mahakama unapata corruption iko hali ya juu, kesi yako ndio iende through, lazima ulipe kitu kidogo, ndio zamanya kesi mingi zinalala. So mimi namuunga mkono sana rais kwa mambo ya corruption.
Labda ukiangalia upande, kwa mfano, kuna wale ambao wanasema kwamba ilikuwa makosa kwa mkuu kama Deputy Chief Justice kupelekwa mbele ya hakimu ambaye ni mdogo sana. Je, unadhania hilo litaweza kusaidia kama siku?
Mimi sioni makosa yote hapo, kwa sababu kama ni corruption, waje shika yaanze na wale watu wakubwa vile imeanza. Sisi watu wadogo ndio tunakimbiliwaga, lakini mambo wenyewe wakubwa hawafikiwi. Lakini sasa kwa sababu walianza na mambo ya juu, tunaunga mkono kabisa.
Okay, Leonard Obanda, I've seen some other residents also shying off the camera, but that will not actually stop this conversation from going on, as that is one of the residents talking about the fight against corruption, saying that they are fully supporting the DPP over this fight, and therefore they are saying that they are going to be behind, and that is a good show that the government is actually ready to go deep, however deep it may be, to make sure that those culprits that have been involved in any kind of corruption are brought to book. Back to you, Dan.
Thank you very much, Zacchaeus Mosame, and the views you've given us, and we believe you shall be giving us more and more as we go along with the broadcast, because we're here to bring to you the views of 190 yourselves, and share with us your views as well on NTV Kenya. That's at NTV Kenya on Twitter, on our Facebook page, and we shall be taking your views on what the current state of corruption and the action being taken against those who have been accused of participating in corrupt dealings in the country, beginning from the big fish. Are you content by the fact that we're seeing more and more big fish, or do some people argue that this is partly a PR exercise, a public relations exercise, one just good for optics, but does it have a legitimate, genuine ripple effect that would actually make people begin having more integrity in their operations. And so we shall be giving you those details as well as we go along. And like I said, we are here to get the views of people from different parts of the country. And now let's cross over to the county of Homa Bay, where Bernard Ojwang is standing by with some views which we're definitely likely to enjoy, because that side of the country always gives us some very interesting views. Bernard, what do we expect, and what is the feeling of the people there?
Well, thank you very much, Dan. We are here at Homa Bay CBD, whereby many people are now saying that they have now regained their confidence with the government, saying that with the current situation where the government are now targeting for big fish. They are saying that the fight against corruption has now taken another dimension. They mentioned with the body mandated in the fight against corruption in the country, now going for the big fish. And you saw yesterday when Deputy Chief Justice Mwilu was arrested by the Anti-Corruption Commission and currently being taken to court. And currently we are just going to talk to some of the locals here in Homa Bay just to tell us what do they feel with the fight against corruption here. Join me is this man Songa Karibu. Wewe unaona namna gani serikali vita?
Serikali ya vita naona kama national government, they are not currently ordered their work of system. That's why you see each and every department corruption. Then we as Kenyans or citizens, you see that they had the prices of, for example, fuel, sugar, and that we are not feeling so good. So we are coming to the government, national government, for them to let the corruption to be spread away. Yeah.
Currently, you are seeing the government is going for the big fish. Do you have confidence?
I have the confidence to speak, but the government, we are Kenyans, we don't see good things that they are doing for us. Yeah.
Well, Dan, remember yesterday in Migori County, you saw some county government officials were arrested, and even here in Homa Bay, some of the county government officials were arrested and even arraigned in court. And the common mwananchi here are saying that they want these people be charged and also sometimes be jailed. And joining with another man here just to tell us how does he feel about the fight against corruption here in the country. Do you have confidence? You start with your name.
Yeah, I'm Eliodo here, and actually I'm a resident of Homa Bay County. The issue of corruption, we have nowhere to negotiate. And just yesterday, you have seen the Deputy Chief Justice was arrested and taken to court. That is a clear demonstration that Kenyans, our president, and Raila Amolo Odinga, they are ready to fight corruption in Kenya. And just the other day, we talked about the issue of corruption in Homa Bay County. I'm happy. And if it is true that these people looted the money of the public, then they should be arrested and the property should be taken back to the common man. And an expense where somebody is keeping on getting rich and the other people are really in pure poverty. The richer, they are continuing to become rich. They are accumulating more wealth. And the common man is suffering. So the best thing that we're actually urging the government, they should even go to the executive. There is no stone should be left unturned. Everybody should account. When you are given a responsibility in an office, you have actually to take care of that office. But a situation where people are suffering and only 3 people are becoming rich, only within 2 years, 3 years, it's a shame. It's a county of shame.
Each and every time you see people being arrested by the Anti-Corruption Commission, they are taken to court and the case is just ended. It's just ending like that. What do you expect? Currently, you saw yesterday, Deputy Chief Justice was arrested. What do you expect?
Yeah. The demonstration of yesterday actually tells me that this time around the government, they are ready. They are speaking their real word. They are not actually sugarcoating the demonstration. Just yesterday, I just repeat myself that we have seen the Deputy Chief Justice was arrested. That is a clear demonstration that the government itself are ready to fight corruption. We have confidence now. The other day they have been looking for the small fish. Well, up there, the big people, they were just passing over. But right now, we are confident that the government are ready to fight corruption. And that is why I'm telling you that these people should even come down, even to the country level, the executive, the assembly. We want to see the total cleansings of the county, so that everybody, you should be actually, when the money is meant to do something, that money should just go directly where it belongs to.
Well, thank you very much. Then I'll talk to the last person here. You'll start with your name. The fight against corruption here in the country, and you are seeing the big top government officials are being arrested and even taken to court. What are your expectations ahead of you? The deputy chief justice is already will be taken to court today. What are your expectations?
My name is Amori Souko. Actually, what is happening in Kenya do impress common mwananchi, because as far as corruption is concerned, it should not be fought among the small people. They should start with the top, because we are not corrupt down here. Yeah. So, like Homa Bay County, recently they arrested some of the officials of assembly. We accept justice to be justice, and evil, let it be evil. We do not need cover up. And even at the national level, let them do justice be justice. Because it's the common mwananchi who is suffering. If you see people, the way people are suffering, if you, for example, if you take like Homa Bay County, our county is lagging behind because of corruption. We do get funds equally, but if you see the way other counties are growing up, you do wonder why. Does it mean Homa Bay is not getting enough money as compared to other counties? In fact, justice should be justice. And if by chance anybody is corrupt, if somebody can be proven guilty, let them face the consequence. I support that, and we are fully behind them. They have our support. We are very pleased with the statement President made that the youths, we've been given power to arrest them. I want them to back us up, because if we see somebody who is corrupt, we are not going to hesitate. We are going to do it alone and report them to the police. And if by chance the police will cover them up, as we think some of them use the police to cover them up, then we will blow the whistle for the government to heal that.
Do you think they already identified corrupt government official will be jailed?
Exactly, because some of them are still rotting in police cells, and some of them were given bond. But what we do ask ourselves, how come somebody was given a bond of 2 million, others are being reduced? So it's like even the judiciary itself is corrupt. Yeah.
What do you want?
What I want is that there should be fairness. The spade the spade that is being used to others should be used to this other people too. Not that some people are being spared, because it's taxpayers' money. I'm talking as a taxpayer. And if you see, I wish you could walk around Homa Bay County. You see how our county is very dirty. We are sliding behind. Everybody's laughing Homa Bay County, and we are receiving the resources as compared to other counties. I do admire Mombasa County. If by chance I could move to Mombasa, I would wish to be there.
Dan, you've just heard from those are the views of Homa Bay County residents. They are saying that the fight should be devolved to the county level. And of course, you saw some days back, the county government or county assembly officials were arrested. Even the county government officials in Migori County were arrested and even arraigned in court. And they are saying that once these people, the corrupt government officials are arrested, they should be jailed. And the issue of cash bail and bond, they are saying that the judiciary should relook at it, and so that at least to ensure that those who acquired wealth illegally through corrupt deals and are repossessed. Back to you, Dan.
Thank you very much, Bernardo Juang, and we expect to hear more from the County of Homa Bay as we go along with this broadcast, and we know that you shall deliver that for us. And still, coming back to the capital, CJ David Maraga is meant to swear in 3 members of the National Gender and Equality Commission this morning. It's set for 10 a.m. That's at the Supreme Court. And Ken Mijungu is there, who is also going to be keeping an eye on what's happening there in regards to DCJ Mwilu's arrest and arraignment and the charges she's going to be facing. And Ken, what should we expect from that side, and what is some of the, the conversation that's going on around this? Ken Mijungu in just a bit once we get the stable signal, but just to remind you that he's at the Supreme Court where Chief Justice David Maraga is meant to be swearing in 3 members of the National Gender and Equality Commission this morning, set for 10 a.m. and after that he's expected to issue a press statement on the same. And Ken Mijungu is the one who's following that up for us on location, and like we had mentioned earlier on, he's going to be speaking to some people there. He's going to be having some guests there, you know, people who are opinion shapers, people who give us some guidance in terms of understanding what exactly happens. Ken, you're a lawyer by training. What are some of the things that we expect to hear, expect to happen today, be it at the Supreme Court or at Milimani?
Right, thank you very much, Dan Mwangi, and indeed we have a full tray today. There's a lot of activity expected from the Supreme Court right here to the Anti-Corruption Court at Milimani, the Magistrates Court where we left yesterday, with the Deputy Chief Justice being arraigned before court. So today the first thing that we expect this morning is the Deputy Chief Justice to be arraigned in court and possibly to take plea of the charges. There are about 5 charges that have been preferred against her. At the Supreme Court, indeed, it's a busy day also. First, to begin with, in the next 40 minutes or so, Dan, the Chief Justice will be swearing in 3 members of the National Gender and Equality Commission, Dan. So the Supreme Court is also expected to be a hive of activities. Right now, it's very quiet, I must say. If you have the impression from outside, if you will just walk to the Supreme Court right now, you'll think there is nothing that is happening here. But behind these walls, Dan, is a beehive of activity. The second in command, the Deputy President of the Supreme Court, has been taken into police custody, and not for anything that is desirable, but for impropriety allegations dating back to 2013. That's 5 years in the making. The investigations have been going on for a long time, Dan. So definitely the people she's been working with as the Deputy Chief Justice from 2016, when she was appointed, definitely are today probably in one of the not the best moods, if I must say, because this is one of the officers of the Supreme Court that must and has exercised the beyond reproach kind of attitude, and everyone has always thought that they are untouchables, Dan. The judges and magistrates are held in high esteem. They are sort of, to say, waifu Caesar. They are as clean as scarlet and should not be tainted or painted in the manner in which the Deputy Chief Justice has been painted in the last few days. So definitely it's something that we are going to stay here and observe and listen. And one of the people we want to listen to this morning, Dan, is the Chief Justice. Right after that swearing in of the 3 commissioners of the National Gender and Equality Commission, we expect the Chief Justice to have an opportunity to address this issue. The DPP yesterday told us that he gave an okay for his deputy to be arrested. Also this morning from the Supreme Court, I'm having 2 advocates. We are having Saitabao Olekanchori, who is an advocate, and we're having Robert Asembo, who will be speaking to us in the next hour about what's happening. And of course, yesterday we had a lot of people speaking about this. I had an opportunity to speak with 2 lawyers on sidebar yesterday. That's Alice Wahome, and we had Peter Opondo Kaluma. Peter Opondo Kaluma, interestingly, and Alice Wahome sat at the Justice and Legal Affairs Committee of the National Assembly that vetted the Lady Justice Philomena Mwilu, and at that time there was resistance from Alice Wahome when she presented herself for vetting before JLAC. And interestingly, we had that conversation yesterday. A lot of things coming out of that conversation, but again, that was not the end of it. That conversation continues today, and in the next hour also, Dan, we expect that the Deputy Chief Justice will be arraigned in court. So we are following all that up for you from the Supreme Court, from Milimani, where we have Trevor Mbijo, who's also holding fort for us there. Later, we'll also try and go to the Milimani Law Courts, where the Magistrates Court is located, to get a perspective. And then, from our conversation yesterday with Peter Kaluma and Alice Wahome and the rest of the panel who sat on sidebar, today is a long day. Taking plea will not be easy because there's already 15 advocates on that panel, including James Orengo, Julie Soweto, and the likes, who are holding fort. Peter Kaluma is joining in. We expect Otiende Amolo probably to be there, but he's traveling later out of the country. So it's a beehive of activity, and one of their agenda today, Dan, is to ensure that the Deputy Chief Justice does not take plea. The other question that arose from the conversation we had about this yesterday, done ahead of our conversation here, is the fact that an opportunity was not afforded to the Judicial Service Commission to look into these allegations like the normal process anticipated at Article 168 of the Constitution, where a due process will be accorded to her, but through the Judicial Service Commission, which ideally would have been that these allegations from the Directorate of Criminal Investigations be forwarded in form of a petition or just in form of those investigations. Now the Chief Justice will then convene a small group of the Judicial Service Commission to look into those allegations done. Once they look into those allegations and find merit or no merit, they have to report back to the Chief Justice. Now the Chief Justice will then take up, depending on the outcome, if there is merit, then he will request the President to constitute a tribunal to begin the process of removal of the judge, who is also the Deputy Chief Justice done. So definitely today is a difficult day for the judiciary, it's a difficult day for the DPP, and of course it's a milestone in the war against corruption. So we are standing here and sitting here to observe what's happening across, and most interesting done for today, all eyes will be at the Anti-Corruption Court, the Magistrates Court, a subordinate court to the Supreme Court that will definitely be trying the Deputy Chief Justice and the President of the Judiciary. Dan.
Thank you very much, Ken Mijungu. Quite comprehensive, and we shall be waiting for more from that end of the broadcast when it comes to our coverage of the state of corruption, and in light of the Deputy Chief Justice's arraignment, where she's meant to take plea at the Anti-Corruption Court, that is at Milimani. Well, like I said earlier on, we have Mel Miendo as well as Trevor Mbija, who shall be having guests on location to discuss the issue and the issues around that. But in studio, we are going to be talking about the economic aspect of it, and what does this mean to you? What does this mean in regards to how much you buy goods and services, if at all? Does it mean that we are going to have slower development? Does it mean that our development has already been jeopardized by this? And what exactly are the take-home points when we see all these arrests? Because some may have termed them as drama, and some may have said this is what we should be in the way forward. Nurdin Haji has been termed by some in social circles especially as being one of Kenya's heroes. One of the guys you get afraid of seeing, we're talking yesterday to some guys and they were saying, when you see Nurdin Haji walking towards you, or the DCI boss Kinoti, you begin confessing your sins. Or if you see the green bulldozer around your estate, around where you are, you start getting afraid if your building is on riparian land or on road reserve, that is. And so we shall be looking at these issues across the board and looking at the different views from different polls in the country. And like we said, Lois Wangoi from Eldoret is going to be giving us some live link and some live discussion in studio as well on the same. Oko Kusa shall be joining us from the county of Kisumu. We've had a bit from Bungoma and from Homa Bay counties, and we shall be hearing more from them as we go along. That is the plan ideally, because we usually know that when it comes to this kind of cases, the taking plea, and Ken Mijungu has already alluded to that at times they take quite some time. They may take quite some time because the number of lawyers who are present and are engaged in the case may take quite some time, and so it may take a long time. But before we get there, we shall be getting into discussions just to give the context so that we can understand what we are getting into and why it's such a big deal. And so now let's get some of the views from the county of Kisumu. Oko Kusa joins us live. And Oko, what is the feeling around there? Are people feeling that the fight on corruption is actually working?
Yes, Dan, varied reactions here. There are people who feel that it is more of plastic, and of course there are people who believe that the government actually is genuine in fighting corruption. So there's a mixed reaction that this latest developments in the fight against graft in the country has elicited here in Kisumu. And just joining me is one of the residents here just to share with us some of his views regarding what has happened lately. We saw there the Deputy Chief Justice Philomena Mwilu being arrested and charged in court, and that of course has caused some little reaction here in Kisumu. Just let's start by you introducing yourself, and then briefly tell us, what do you think about the ongoing fight on graft in Kenya?
My name is Maurice Ochuka. I'm a resident of Kisumu. First of all, I want to say that we highly support the government in what they're doing in curbing this menace called corruption. But all the same, we want to actually condemn if at all the fight against corruption has been politicized, because what we saw yesterday is taking back to what the president said last year, that we will reverse it. So we are actually, somehow we are trying to say that we are not able to correctly say that it's the real corruption that is being fought. And if it is real that they're genuine about this thing called corruption, so that they want to do away with it, then we highly support, especially what they have been doing. We can see governors are being read in court, other dignitaries are being read in court. That one we really support. But as far as the case of Mwilu is concerned, we are a bit concerned on the way she was brought to court yesterday. And we believe that if the government is honest about fighting corruption, that should not leave everybody behind. Those who are culprits should be brought to book.
You've mentioned something about governors, and of course we know that the vice is also rampant in counties, but we've never seen, so much force happening in the past. Do you think that so far what has happened is satisfactory?
To some extent, I can say true, because we heard from the DPP saying that they are going to rein dignitaries to court. So we expect governors and deputies, all the corrupt leaders from various counties being brought to book. Yes.
Okay. And maybe going forward, you've talked about having some faith in what the government is doing. And of course, we spoke with some other people who think that this is all, plastic, that it's more of like a PR.
Based on Mwilu case, we want to look at what the president said last year, that we've seen what the judiciary has done and we shall revisit. That statement is so strong to the extent that if you can analyze it critically, you can able to see the war against corruption, especially on judiciary. And Mutunga himself, the CJ, also condemned it, the arrest of the deputy chief justice. So to some extent, we might see it has been politicized.
Okay.
Yes.
Well, thank you very much. Let's hear from this gentleman too. Let's start by introducing yourself, sir.
Yes, my names are John Rogaya. Yeah.
Okay. So on the fight against corruption, you've witnessed what has happened in the past, in the recent past. Do you think that the government is genuine in fighting corruption in the country?
Yeah, to some extent, I think they are genuine, but in other words, again, they are somehow a bit political about it.
Why do you say so?
Yeah, because the way you see some they are doing, they are not genuine.
Mm-hmm.
Yeah.
Can you cite some instances where you think that it was more of like a PR?
Yeah, even like the one which happened yesterday, I don't believe it's genuine.
Why?
It's something, it's somehow retaliation. Yeah.
Or you think it's more of like a retaliation? And how about the other time we saw the governor of Busia, Sospita Ojamong, being interrogated by EACC. Do you think that was genuine?
Yeah, it was.
Mm-hmm. What can you say about it?
Yeah, it was, because the way things were done, the evidence they were producing, it was genuine.
Okay.
Yeah.
Fine, let's hear from the third gentleman here, and can share with us his views too regarding corruption in the country. We've seen a lot of movements. Yesterday, the Deputy Chief Justice Philomena Mwilu was arrested and charged. Do you think that this is the right direction, that the country is moving towards the right direction in fighting graft?
Yeah, the country is going to the right direction, and I fully support the government for fighting corruption. Yes.
How?
Through arresting the people who have rooted the country, and is setting a good example that we are heading to the right direction. Yeah.
Do you think that is enough?
It's not enough, but it's supposed to go deep to arrest all government who have rooted this country, who are making Kenyans to be poor.
Some of your colleagues who have spoken ahead of you think that Mwilu's arrest and being taken to court is more of political. Do you agree or disagree?
That they are fighting injustice. Yeah.
Okay.
Yeah.
So moving forward, what else would you like to see? Would you like to see that being done, the same thing being replicated in the counties?
Yeah. It needs to be replicated even in counties and set a good example to all officials who they need to set example for justice.
Thank you very much, sir. Thank you very much. Let's take this young man here. Tell us your name and then briefly your reaction or comments or opinion on the recent fight against corruption in the country.
I'm Eliakim. I'm happy to see that steps are being taken towards stopping the problem of corruption. It was much worse when nothing was being done. So at least a step has been taken forward in solving the issue. So I just hope to see more of such actions being taken. Yeah, at least it makes the future seem brighter for people like me. Yeah.
Okay. Yeah. In your opinion, I mean, so what are some of the things that you think corruption has hindered in our country today?
Well, I can't talk about as per now, but the future for me, corruption, I see it will affect the youth so much in the sense that getting jobs, things like nepotism, tribalism, they will affect us largely. But when such things are dealt with, they make the future seem better for me in terms of employment and opportunities. Yeah.
Thanks, man.
Thank you very much.
Thank you very much. Well done. Those are some of the views of residents here in Kisumu. You've heard it, and they are very clear. Mixed reactions. There are some thinking that the fight is more of political. Others, have a feeling that this is genuine, and they are actually satisfied with the steps the government has taken so far, and they are optimistic that if this is going to go on this way, then we are going to see some reduction in matters corruption in the country. Yes, back to you, Dan.
Thank you very much, Oko Kusa, and the views from the county of Kisumu, where we've seen varied views and some very poignant points coming across, such as people talking about the people who are corrupt are causing Kenyans to be poor, and we shall look at the dynamics to that. But just before we get into our studio discussion in regards to the economy, let's cross over back to Supreme Court, where Ken Mijungu is standing by, and he's got a discussion he's going to have briefly. Then we can come back to studio. Ken, over to you.
All right, thank you very much, Dan. And indeed, we are right here at the Supreme Court. And as we promised, this conversation continues right here. And who better to drive this conversation than Kanchori Setabao? He's an advocate of the High Court of Kenya, and he's been following this very closely, Dan. And he has a perspective just like every lawyer who's been handling this matter. Let's speak to him. Good morning and good to see you. Of course, the first question that I would ask is, where is this headed?
Thank you, Ken. I think for me, let me begin by saying that the fight against corruption is both noble and laudable. And society can, as they say, is like fish. It begins to rot from the top. And if you want to deal with corruption effectively, you have to start from the top. Having said that, the fight against corruption equally must be done in good faith. It must be done in the public interest. And with regard particularly to the arrest and arraignment in court of the Deputy Chief Justice, I personally have mixed feelings on the same. And the reason that I have mixed feelings is because, like many Kenyans, I support the fight against corruption 101%. However, I am concerned as a lawyer and as a Kenyan who wants to see institutions in this country respected and their independence as well respected. And therefore, I'm concerned about the perception that the arrest of the Deputy Chief Justice might have on particularly the independence of the judiciary. Ken, for me, I would have wanted to see it done differently. Okay. I would have wanted to see a situation where if indeed the Deputy Chief Justice has been accused of having done any impropriety, the process, as far as I'm concerned, should have taken the Judicial Service Commission route. Okay. And if necessary, then the Deputy Chief Justice will be suspended if found to have committed any wrongdoing, and then after suspension, she can face whatever criminal prosecution. that then can be brought against her.
Then the question to you now is, why then? Because I believe the DPP is a lawyer, and there are a lot of lawyers who are put on this. But why were they hurrying with this? Why didn't they follow that process?
Well, I cannot answer that question satisfactorily, Ken. But I think the reaction and the comments by the Director of Public Prosecutions yesterday will tell you that even the Director of Public Prosecutions, because like you say, he's a lawyer and I believe one of good standing and as well as one of good intentions. Yeah, is a prominent lawyer. He's one who we have seen wants to uphold the integrity of his office and indeed to do a good job. We have seen that. I think we can give him that. But you saw how he was quick to defend himself even before there were any accusations.
You mean that's at the press conference?
At the press conference yesterday,
okay.
To say that this decision has, has been done above board. This decision has not been taken lightly, and all this. So that tells you that even the DPP himself is concerned, or has some concerns or reservations with regard to how this action or that action by his office might be taken by the public.
Okay.
Yeah.
All right, but he looked very confident from where I was sitting yesterday as I watched the DPP. He looked very confident. Of course, he couldn't say he's not confident, and he couldn't say that he didn't have enough evidence. But that kind of confidence can only translate to enough evidence.
I don't think I would say that, because if every case that is taken to court, the prosecution would always say that they are confident. But of course, we know that conviction rates in this country are very low. And that will tell you also that perhaps we should not always be very, optimistic about, the chances of any case that has been has been taken to court succeeding. Yeah. So it is one thing to take a matter to court; it is another thing to prove it. And I wouldn't say that his confidence or perception of confidence, or him appearing to be confident, is an indication that he believes that the case is airtight.
But the difference in those cases you're telling me is they don't involve the Deputy Chief Justice of a country.
But we have seen the charges. We have seen the charges that have been brought against the Deputy Chief Justice. And personally, I would want to single out one of the charges, the one that relates to tax evasion of 58,000 shillings. And that particular one, to me, raises is I would say rather suspect, and I say that for a number of reasons, particularly two reasons. One, we know that the issue of tax evasion is traditionally and historically one of the ways that regimes have used to rein in on persons who are perceived to be anti-regime. So that I think is a matter of public knowledge. Secondly, the policy of the Kenya Revenue Authority recently was communicated by the Commissioner General himself that it is no longer about punishing tax defaulters, but it is about tax collection. And we would have expected that if the Deputy Chief Justice has been found to have defaulted in the payment of our taxes, one of the ways that that could have been handled is for her to be notified of that default and for compliance to be required of her. And it is only after she has failed to comply that then, prosecution. Because indeed, tax evasion is a criminal offense. But there could have been a process that would have preceded the prosecution, in my view, particularly on that issue. I'm not able to comment on the other charges, but I think one of the things that most of us, you have seen the reactions, particularly from the public, if this issue of the charging, the arrest and arraignment of the Deputy Chief Justice had come before the Supreme Court petition, presidential petition, if this matter had come before the President's promise to revisit, I think Kenyans will have taken it, differently, okay, and perhaps more positively. Okay. But this has to be seen, and I think Kenyans cannot help but to see this particular action in light of those two events, which are very fresh in our memories. Okay. Yes.
All right, and I know we're walking a tightrope now of sub judice here, but we are also glad that she's not taken plea, so we can still talk about this. Let's talk about the charge that talks about obtaining favors, receiving gifts, and a personal loan of 12 million shillings. One, how do you prove that I obtained a favor? Secondly, what's wrong with having a personal loan, you know?
Ken, like I said, I am not in a position personally to comment on that. Firstly, because I really don't have any information one way or the other on this. We haven't seen which cases would be brought to, comment or to testify with regard to these matters. Only to say that bribery generally, and this goes back to as to how confident can the DPP be on this particular case. Bribery, like rape and other offenses, are offenses that are done in utmost secrecy. And both the giver and the taker are usually persons who are not willing to be to come out publicly many times. And therefore, my personal view is that it will be very difficult to prove anything that regards to bribery. And we have seen even in other matters like election petitions, which are some of the cases that we handle, and many of them involve the issue of bribery. It is often the last thing that can be proved.
Okay.
Yes.
All right. Perhaps now we talk about the unforeseen consequences, the ripple effect to the judiciary. It looks very quiet right now, but I'm sure there's a beehive of activities here. The Chief Justice, by the way, is expected to swear in 3 members of the National Gender and Equality Commission. So we expect the CJ to talk to this. But talk to us about the ripple effect and the unforeseen consequences of arresting the Deputy Chief Justice.
That, Ken, is one area that, there are so many unforeseen and perhaps undesired consequences. You saw, I saw yesterday, and I'm sure you also saw, that FIDA has already stood with the Deputy Chief Justice. And I think they do this for good cause. This is not the first lady Deputy Chief Justice that is being hounded from office.
Yes.
We have seen other judges, male judges, who perhaps even had worse accusations leveled against them, but who were not handled in a manner that is as severe as we saw how the lady Chief Justice was handled, and she was handled as well. So we saw FIDA coming in. I expect that the Judicial Service Commission would also play a role, and I expect them to make a statement on this. Okay. I expect that the magistrates and the Judges and Magistrates Board would also have something to say about this. Okay. I expect the Law Society of Kenya also would have something to say about this, amongst others the ICJ and all this. Okay. The reason is, there is really a very thin line, Ken, between a judge and the court. So the judge essentially is a representation of the court. The judge is, once you go after the judge, you have to draw, the line is very thin as to whether you're going after the judge or after the court. Okay. Yes, judges do not have security. They have security of tenure, but they don't have immunity from prosecution. However, the reason that the law and indeed the Constitution sets out the manner in which judges can be removed would make you believe that if there's anything against a judge, first consider removing them, then after you have removed them, then consider prosecuting them. Okay. So that we don't have that interplay between the conduct of the judge and the office itself. All right. Yes.
All right. Thank you very much. Thank you very much for your perspective. That's Setabao Ole Kanchori. He's an advocate of the High Court of Kenya, Dan, and of course sharing his perspective. And we still have to be very careful on what we're talking about. We're only glad that the plea was not taken, and that's a subject of discussion later. In the next hour, we'll be speaking to another advocate on this. But Dan, right now, in about 10 minutes, if the Chief Justice works up to the clock, we expect him to be swearing 3 members of the Gender and Equality Corruption Commission. Right after that, we expect him to talk to this because it's very important to hear the voice of the Chief Justice. And as Ole Kanchori has just mentioned, the LSK has to speak to this also. And we expect a lot of voices around this. And of course, apart from that, we expect that outcome from the court. We know she's been released on bail, but we still have a lot to listen to and hear. And this is precedent setting done. So let's wait and see what happens. But we're still here at the Supreme Court, Trevor Mbija, at the Anti-Corruption Court at Milimani. And of course, I'm here with my colleague who also will be talking to us later on about this. But right now, let's get back to the studio. We'll get you in about 10 minutes or so as we wait for the Chief Justice to get ready for the swearing in. Done?
Thank you very much, Ken, and we shall be crossing over to you live once the CJ begins to address, to speak and to just have the ceremony of the swearing in happening of the 3 commissioners. Now in studio I have Tony Watima, who's an economist. You've seen him here before and he's of great insight. And Tony, first, welcome.
Thank
and
you.
In regards to this whole conversation, we've had it before and it keeps going on and we're seeing more and more big fish being netted, being arrested. There's someone there who may not see the connection between myself as a common mwananchi, as we may call them, and the fact that we've got people who have been, stealing public funds. What is the connection? Just for the sake of those who may not understand what the connection is between someone who steals public funds and the common mwananchi.
Thank you for having me. The connection is that the pervasive nature of corruption is that it's public resources diverted for private interest. So we buttressing private interest using public resources or public office. So these resources are supposed to go to the general public for the common good of the average Kenyan. But somebody instead is taking that resources on their own. So that means the opportunity cost of corruption is quite high, because if a huge resources is allocated to one person when it's supposed to be disbursed to a number of Kenyans, it means that there are quite a number of Kenyans who will lack either resources to do or to continue with their work, or it means that government cannot fulfill certain promises, whether it's road construction, whether it's subsidy programs, whether it's social programs. So the connection is that you are being denied services because somebody is amassing wealth for their own private interest using public resources. That's the pervasive nature of corruption.
Okay, and some of the issues we've seen in the charges is regards to tax evasion.
Yeah,
and could this also point to the fact that they may have, if this was true, that let's not decide that she's already, let's not rule her as guilty before the court has done that. But in the event that this is true, what is the likelihood of collusion with KRA officials?
The most interesting thing when I read that charge sheet brings me to, as a public policy analyst, there are two things about that charge sheet on tax payment, lack of failure to pay tax, the allegation. Now, the first one is that how did she get a tax compliance certificate when she was vetted for the DCJ position? Which means that if it's true she didn't pay it, then there is a question that is the tax compliance certificate really a vote of confidence from KRA that you are tax compliant? That is one of the biggest questions that we need to ask. Because it's a number of small amounts that accumulate to 58,000 and all that. So it's quite a string of like three, 4 transactions. So what I'm surprised is how did KRA miss a string of 3 to 4 transactions and were able to clear her when she was being vetted for the DCJ position. The second one is that are we criminalizing failure of tax payments? If that's the case, then we need to decriminalize it. And the issue is that I'm not sure how DPP was roped in. Did KRA bring the DPP in this case about tax compliance? Because how tax compliance should work is that you're not punishing people to pay taxes. You're encouraging people to pay taxes. So your level of increasing tax compliance becomes higher. So in the sense that what you do is that if somebody fails to pay tax, what you do is that you're able to give them a letter saying that this is the kind of tax arrears that we need from you. If there is a penalty, you put it up, and then you give them a time frame we need to pay this tax maybe in 7 days. Failure to do that, then you can go to court and you seek maybe to freeze accounts until you make a payment. Now the issue is that the end game should be that you're seeking a payment like a debt. You're seeking somebody to pay you. Now when you institute a criminal case like this one, you're not at the end game of getting that money back. You're instituting a criminal charge. So it becomes difficult if you are to operate on the such premise for everyone who is not paying taxes. It will become very expensive affair if you are to take everyone to court because of failure to pay taxes.
But what's the balance between, like you're saying, you need to decriminalize it,
Yeah.
the fact that someone who is not remitting their taxes is actually doing something unlawful?
Yes. It's the same argument.
If there may be the argument that if you become too soft with such a person, it will create a precedent that no one will really be as keen to remit their taxes.
It's the same argument that is being made by traffic rules. We decriminalize traffic rules. It's not that we are being soft exactly, but the end game is that we are trying to achieve a purpose as KRA. We're collecting more taxes. So the biggest issue is that we are trying to use the minimum resources we have as KRA to collect a huge tax arrears out there. So in terms of enforcing compliance, you don't institute a criminal charge. You're trying to, because we already have quite a number of rules that KRA uses that you cannot, they already can punish you. You can even freeze accounts of somebody, because that one is still, it's not a criminal thing. You can freeze somebody's accounts. So until you pay that taxes, then you can access your account. That's one of the most things that people use. So in this case, I will expect that, because DCJ is a public official, you know her pay slip. If she has a tax arrears of 58,000, you can rain on the employer and tell them, we need a 58,000 tax arrears from the DCJ. And then you're able to collect that tax. So the end game from the KRA part is that you're able to collect all the taxes and tax arrears that are out there, instead of instituting a process that takes a while, even if you're to recoup that. Yeah, that's the biggest question. It's a time convenience that you're able to work with the little resources and you work efficiently in terms of tax collection.
So this is basically saying that it's moving Kenyans' mindsets away from tax being a painful thing to actually being investing in development of humanity.
And that's the biggest thing about compliance. You're able to encourage people that it's a good thing to pay taxes, and there is a room that even if you default, we are giving you room that you can comply, rather than we are scaring you that you have to pay tax. That's the scary thing about instituting criminal charges against tax arrears.
Okay, we'll get back to that conversation in just a bit. For now, we take a short break on our broadcast, but shall be back and continue the conversation in regards to what it means to you. What is the impact of corruption on things that are significant to the economy, such as debt and such as ease of doing business and the likes, and we shall get into that, as well as look at the views of people from the different counties. From the county of Uasin Gishu, where Lois Wango is in Eldoret, we have heard already from Kisumu, Homa Bay and Bungoma counties. That should not be the last we hear of them, hopefully, because these proceedings may take long with the DCJ goes in to take a plea. It may take quite some time, but before then we're going to equip you with the information you need to have to ensure that you understand the issues around that. And like I said, Trevor Mbija is at the Anti-Corruption Court, as well as Mel Mendo, and Trevor will be having a small panel to discuss the issues as well from the legal perspective of things and the policy analysis of the same, as we get deeper and deeper into this and give a better understanding of the issues. But for now, we'll take a short break. We'll be back after this. after when the Deputy Chief Justice was arrested and arraigned, and today she's meant to be presented to court, the anti-corruption court, that is, to take plea. And aside from that, her boss, that is the Chief Justice, David Maraga, is meant to be addressing the nation, as rather speaking after he swears in some commissioners at the Supreme Court where Ken Mijungu is. And we shall continue the conversation across the country, the different counties and the likes. And so now, let's cross over to the Milimani Law Courts, where we have the Anti-Corruption Court, and we have Trevor Mbija standing by or sitting by with his panel to have some discussion. Then Trevor, has any sense of activity happened around there? Have we seen, like, the DCJ has been brought in? She was meant to be presented in court at 9 a.m. It is now 10 or 8 a.m. and we're yet to hear anything. Is there any kind of activity we've seen towards that?
Well, good morning, Dan. African time, absolutely, like you said, it was supposed to start around 9 a.m. It's about past, it's an hour later. It hasn't started yet, but there's been a lot of activity around here at Milimani Law Courts. We are getting conflicting information. There's some people are saying the DCJ is already within the precincts of the law courts. However, we haven't seen her though, but I've seen several legislators here, including Wiper leader Kalonzo Musyoka. He also walked in a few moments ago. We've seen here Senator James Orengo. He also doubles up as the legal representation for DCJ. Philomena Mwilu. We've seen Cliff Ombeta. Several lawyers have been in and out, and there's been a lot of people. In fact, I think there's so many people that the courtroom has been moved 3 times since we got here in the morning. It means there were so many people who could not fit in the first courtroom, so it's been moved 3 times up to now. But we haven't yet seen the person who is the accused so far, who's the DCJ, Philomena Mwilu. She's expected to come in here this morning and take a plea after having been released at a 5 million personal bond. Like the DPP read out yesterday, there are about 5 charges that she's facing. The first one is the Lady Justice abused her office for personal gain, based on the statement that the DPP read yesterday. He also said that she accepted a gift in the form of money in circumstances which undermined public confidence in the integrity of the office, and obtaining execution of security belonging to Imperial Bank Limited, now in receivership, by false pretense, unlawful failure to pay taxes, and that another one is conducted herself in disregard of the law. However, for now, we have my panelists with me here. David Osian, public policy expert, is joining me. Joy Mudivo, advocate of the High Court, is also with me. But before we get into that discussion, Dan, I'll throw it back to you, and then we can link up later on and discuss the situation. Dan?
All right, thank you very much, Trevor, for that, and we shall be looking forward to that discussion in regards to the legalities and the likes. And what you're seeing on your screen right now is a case for the NLC chairman, that's Mohammed Swazuri, and you know he has been he was arrested not too long ago. He's been among those who've fallen into the trap of the DPP in what has now been commonly referred to as Kamata Kamata, as it was on Fridays ordinarily, but he's among those who are arrested, and this was in regards to a land case. It is not some of the, it's not the Ruaraka that had been a big story before. It was a different case, and he had been in court there just a few days ago, fighting for his, the granting of access to his office, which he was given, which though it was, limited access, as we've seen some of these leaders in the different state organizations, state departments or organizations who have been fighting for their rights have been denied access. So let's listen in for just a bit.
Yes, Your Honor, we confirm.
For Professor Mohammed Swazuri.
Yes, we are acting together with
Yes, now you can see.
inform you in court.
Very well. I think now that's no longer an issue now. I think that one is settled. That is settled. At least that is confirmed. Yes. Yes.
I did not know. I'm informed that we do not have amongst the documents the investigation diary and the extract of the OB that informs the initial report that was made by the complainants in respect of the offenses of the charges in question.
Yes.
Of course, that will be the questionable legibility. We apply that, Your Honor, if possible, that scans of the original statements be supplied, and this on behalf of all the advocates, so that we do not have to worry about the copies. The entire legal copies that the professor has spoken about, and all the advocates are talking about, will be cured. If they just scan, it's not expensive. They scan and give us copies that we can read. Thirdly, Your Honor, these pleas are becoming too many. There are many, and then we have all many cameras. We're getting a bit tired. Your Honor, can we get a close date? We hear these matters and finish it. We can test the first matter. We can test the first matter.
But you see, the first thing that we need to do is the pre-trial.
Yes, come back next week to the pre-trial.
Yes, I'm ready to give a date for the trial. As soon as we are through the pre-trial, I'm also very much ready to hear the matter.
We are going to finish these things.
Yes, that is true. Yes. So what we do, what we agree is that, okay, prosecution, in respect of that application by Professor Ojenda, do you want to say something?
Yes, in terms of the stamp copies, we already have soft copies. If they could just share
You have soft copies?
Yes. If they could share their email addresses, can be able to, they can dial get to my and have the same sent to them via email. In terms of the investigation diary, Your Honor will post that application. An investigation diary is an internal investigative tool and is indeed not part of evidence, but the prosecution would be relying on. And therefore that particular application in terms of the investigation diary is enforced.
I don't want to do that application now. So what we do, let's agree that we did take a date for the pre-trial. For the contested documents, we will have a date where you can argue the application and the court will make a ruling on it. Yes.
Something very small. Some of the documents that are supplied to us are masked, and it is not in the political.
That is a case that's ongoing of for Mohamed Swazuri in regards to the SGR compensation, which saw him alongside the CEO of the NLC and the managing director of the Kenya Railways Corporation, that's Atanas Maina, being arrested alongside a number of other people. And we shall be giving you details on that as we go along with the day. But back to our studio conversation with Tony Watima, and we see there's an aspect of Imperial Bank which went down in the DCJ's case.
Yes.
Who is dropping the ball with the banks? Because at a point of all these corruption cases, I know a number of times we've been told that when it comes to the corruption aspect, people will do hard cash. They don't want to get into the system. We've heard of people having vaults, a whole room in their houses committed to vaults. But in terms of the banks, who is dropping the ball? Is the central bank dropping the ball? Are the banks themselves, or is it one or the other or both?
I think it's both. There is the self-regulation by banks because they are draft rules that you need to comply with. In terms of cash deposit that you can make, that a client can withdraw, it's well stated by central bank. But we see that people still withdraw billions and millions in cash. On the other side of central bank has not reined in on banks in terms of giving penalties and those that float rules that are well stated by the regulator itself. So the ball has dropped. You look at Imperial Bank. Imperial Bank, people were able to use clients' money and do all their business out there. And then this money didn't return back quickly. So the money got lost somewhere. And at the same time, central bank has systems that can check all these things that are happening because it's a system that is networked. Central bank dropped the ball. You look at Chess Bank, it was central bank that dropped the ball. You look at Dubai Bank, it was central bank that dropped the ball. So it lies squarely on the regulator because that's the role of the regulator. And the biggest role that central bank is mandated as a regulator is that monetary policy is a very sensitive thing. So you have to be very strict in terms of banking so that you have a stronger monetary policy. These, at least, we are able to navigate the number of banks that were collapsing. But it shows that for an investor specifically, let me talk as for an investor who wants to go into banking, it means that there is weak loopholes within the regulatory framework of the central bank. And you look at, as Kenya tries to give itself a position that our financial hub, these are the things that people look at. How strict are your rules? How convenient that can we operate, that there is no money laundering kind of a system or a tax haven, a money laundering haven. And central bank needs to be very, very aggressive in reining on banks that float rules. Because those, quite a number of banks that basically banking, how it works is, most of their money is not theirs. It's depositors who bring their money. So the only person who can keep depositors' money safely is the regulator itself, central bank.
And so this means that hopefully we should expect the DPP to visit the bank soon. And he had actually committed to that during the NYS cases.
Yes.
The first set of arrests, he said in the second phase, we'll see banks. And this means that we are likely to also see central bank being in there.
Yeah, a number of central bank officials are indicted in the collapse of a number of banks. We are yet to see those prosecutions coming. That one has to be, because these are public officials. We need to instill public confidence in terms of integrity and rule of law. So that DPP has to go for central bank officials. For the bankers, they are bankers who literally flouted rules of central bank. People can withdraw 100 million when it's not allowed in law. People have to be held to account on anything that you do. They have consequences on any action that you do. So these are the questions that, even if we talk about the Philomena Mwilu's case that she's being brought connection to central bank, Imperial Bank, we need to see a number of cases of the same about banking and all the banks that collapsed. Because you look at Imperial Bank, it collapsed in 2013, 2014, around there.
Yes.
Those are around 5 years. People are waiting to see those cases come in.
Chase Bank happened sooner and has been resolved.
Yes, because the sooner we do it, because there are a number of, you are able to have a watertight case the sooner you do it, than you delay it, because there are people who will interfere with the cases and all that. So people will want, even in terms of public perception, people will have confidence that there is quick response from the DPP when you prosecute cases in a timely manner.
And you can even see one of the witnesses in the DCJ's case is a central bank employee, and that is, he's called Gatere, and he's one of the employees at CBK, one of the officials at CBK. So we see they're beginning to rope in, much as is coming as a witness on this one. But now, still going on the larger aspect of corruption and the state of corruption, what is its impact on investment, be it local or international, especially international, because you know when you're at home, you know how you can, you know the promise, but someone who is coming from outside may not know.
Yes. Let me use an example here. Yesterday I was with Simon Kimutai of Matatu Association, Matatu Owners Association. So he was telling me, you're doing a cost accounting on if you run a matatu, you as the owner, you get around 4,000 shillings. That's your profit. That then you can pay yourselves per day.
Okay.
So at some point you find that cops will come and rain on your matatu and all that, and they will demand at some point maybe 3,000. So you find yourself that the owner of the matatu is earning less and the cop is earning more. So in their calculation, they say that in a year, because they have around 30,000 buses registered with them, in a year they can count it as 1 billion. They lose 1 billion because of tax bribery to traffic police. So it tells you that how it's a misallocation of resources, because these are profits that are supposed to go to the owner. Maybe the owner can invest back and build that sector well. So it's diverted to other people, and for them it's a selfish gain and private interest. So if you look at how corruption works, is that you basically try to deny other people an opportunity, and then it's closed to a few people. In terms of aspect in the investments, it's a very critical part, because when you look at the corruption index, you look at World Bank ease of doing business, those are the parameters that are used to calculate. And for any international investor out there, those are the things they look at seriously, because where there is high corruption means that there is high regulatory bureaucracy. You find that you will have to register with them maybe 10 processes, and you will have to pay people within those processes. And so investors look at such a place that it's not convenient for them because there is no regulatory framework. And also that means that your profit margins also will have to be trying to pay people. So it becomes a barrier to investments. And these are serious things that we need to work on. And the biggest aspect that we talk about public sector corruption, but there is big private sector corruption.
Okay.
Yeah.
Okay, just to remind you that the Chief Justice David Maraga is meant to be swearing in 3 members of the National Gender and Equality Commission. It was set to begin at 10 a.m. It's about 22 minutes on, but we're standing by, and like we mentioned earlier on, Ken Mijungu is there, and the pictures you see on the screen are the preparations for that ceremony. And the expectation here is that the CJ is going to speak on the issues of corruption in the judiciary, and with the latest issue, the latest thing coming up being the Deputy Chief Justice Philomena Mwilu being arrested over corruption claims. And so we wait to see what happens. So what you're seeing on the screen is the room where the function is meant to be happening, where the CJ is expected to come and speak after swearing in 3 members of the National Gender and Equality Commission. And so we wait for that. We wait to see what he's going to say. I mean, coming from a point where he has also spoken very vocally, especially on the exclusive interview he had with NTV when he spoke to Olive Barrows and Jane Goiri. He was very keen on saying fighting corruption and that he shall be on the forefront in regards to his jurisdiction, with all pun intended, his jurisdiction, and comes to the judiciary. He said that he's going to be on the forefront of leading that, and as well as the other judges who are under him. And so now, this being his number 2, his deputy, the deputy president of the Supreme Court of Kenya, this becomes a concern. And so it probably would be good to read his mood and just to understand how he's feeling, where he's at when it comes to this whole issue of corruption and it having hit his deputy, at least the allegations as far as we know. And so we shall see what shall be said. So just stay tuned. We shall be definitely going into that in just a bit. Once the event starts, we take it live, as we also look to having some conversations going on at the Milimani Lockouts. And actually, from what you can see on your screen is that it seems it's about to begin. We could see there's already somebody at the podium who's beginning to speak. That's Anna Mari, that's the registrar of the Supreme Court, who's there beginning to speak. And let's listen into what exactly is happening as we follow the story.
National Gender and Equality Commission, the Secretary, National Gender and Equality Commission, members of the Fourth Estate, distinguished ladies and gentlemen, good morning. Mine is to welcome you to the judiciary for the swearing-in ceremony of Dr. Joyce Mwikali Mutinda as chair of the National Gender and Equality Commission, Dr. Murithi Chomba as member, and Priscilla Nyokabi Kanywa as member. The chairperson and members of the Commission on Administrative Justice, as the chairperson and members of the Commission, the National Gender and Equality Commission, were appointed by His Excellency President Uhuru Kenyatta through Gazette Notice number 8534 and 8535 respectively, dated 17th of August 2018, which was published on 20th of August 2018. I now take this opportunity to call Dr. Joyce Mwikali Mutinda, chairperson, to take her oath of office. Dr. Mutinda. Yes, please. This is Dr. Mwikali Mutinda. Just read this. Yeah. You're a Christian? Yes. With the right hand or left? With the right hand.
I, Dr. Joyce Mwikali Mutinda, having been appointed the chairperson of the National Gender and Equality Commission, do solemnly swear that I will at all times obey, respect, and uphold the Constitution of Kenya and all other laws of the Republic, that I will faithfully and fully, impartially, and to the best of my ability discharge the trust and perform the functions and exercise the powers devolving upon me by virtue of this appointment without fear, favor, bias, affection, ill will, or prejudice. So help me God.
Congratulations, Chair Dr. Mutinda.
Thank you.
May I now call upon Dr. Mwilu Chomba to take his oath of office. Okay. Please repeat after me. I, Mwilu J. Chomba,
I, Dr. Mwilu J. Chomba,
having been appointed as a member of the National Gender and Equality Commission,
of the National Gender and Equality Commission,
do solemnly swear
that
I will at all times obey, respect, and uphold
respect and uphold
the Constitution of Kenya and all other laws
of the Republic,
that I will faithfully and fully impartially and to the best of my ability discharge the trust and perform the functions and exercise the powers devolving upon me by virtue of this appointment without fear, favor, bias,
affection,
ill will, or prejudice. So help me God.
So help me God. Left or right? Right. This is right.
Okay. Right there.
Okay. Oh, really? Okay.
Congratulations, Dr. Chomba.
Thank you so much.
Last but not least, I call upon Priscilla Nyokabi Kanywa to take the oath of office.
I, Priscilla Nyokabi Kanywa, having been appointed a member of the National Gender and Equality Commission, do solemnly swear that I will at all times obey, respect, and uphold the Constitution of Kenya and all other laws of the Republic, that I will faithfully and fully, impartially, and to the best of my ability, discharge the trust and perform the functions and exercise the powers devolving upon me by virtue of this appointment without fear, favor, bias, affection, ill will, or prejudice. So help me God.
Congratulations, Priscilla. This brings us to the end of the swearing-in ceremony. I now want to ask the Secretary to the National Gender and Equality Commission to give us a few remarks.
Honorable Chief Justice, Honorable Chief Registrar, Chairman, Chairperson, National Gender and Equality Commission, Commissioners, distinguished guests, ladies and gentlemen, may I take this opportunity to congratulate our Chair and our Commissioners and thank the Chief Justice for swearing them in. I think we thank you for the efficiency because this has happened so fast. From the time of the interview to the time of swearing in, it has taken such a short time. Honorable Chief Justice, the issue of equality is a major issue in Kenya. When we have over 90% of girls in northern Kenya undergoing FGM, when we have many Kenyans living in forests, when we have many Kenyans living in slums in deplorable conditions, when women are battered, when we find in many parts of this country, the illiteracy level standing at over 40%, we have a lot of work to do. Take this opportunity to welcome my chair and my commissioners to give us policy direction to implement a very huge mandate. I welcome you and I thank you and we will support you as Secretariat. Thank you very much.
Thank you very much, Mr. Sola. May I now ask the Chair to speak to us.
Thank you very much, Honorable Chief Justice and Chief Registrar, the commissioners present, because we have others who are not present today, they are still on duty, the staff, members of the fourth estate, ladies and gentlemen, all protocols observed. I'm very, very delighted today. I'm very, very happy. And why I'm very happy is because the Gender Commission, which came into force in 2012, is beginning to get to be understood. We are calling this a phase 2, because the phase 1 was setting up the infrastructure that is already in place. And before I proceed, I want, on behalf of the good lady and gentleman, I wish to express my profound gratitude to His Excellency Uhuru Kenyatta, the President of the Republic of Kenya, and the Commander-in-Chief of the Kenya Defense Forces for appointing me and my colleagues to serve at the National Gender and Equality Commission. They call it GEG. These appointments are a testimony to the President's stated commitment to ensuring that the country makes strides to bridge the gender parity gap and ensure the inclusion of special interest groups in our national development agenda. When I talk of special interest groups, I'm talking of the aging, not the aged, the aging, because we have some aging society. We are talking of the marginalized. I am very passionate about the boy child who is being left out because we are very busy with the girl child. Not that we shall forget them, but I'm saying these interest groups include all of us. We should be part and parcel of not only national development, but also international development, because we are part of that globe. We wholeheartedly embrace the task bestowed upon us through these appointments and promise to do whatever it takes to deliver mandate of the Commission. As the incoming chairperson, I'm fully cognizant of the huge and unique mandate conferred by the Constitution of Kenya. You can just see behind you the Constitution of Kenya 2010, because it's the one that came up with this, to the National Gender and Equality Commission of promoting gender equality and freedom from discrimination. This mandate has been translated into the 16 specific functions of the Commission by the National Gender and Equality Commission Act 2011, which is not talked about very much. Remember, mandate 16 is not very few, and therefore we have a lot of work to do. I fully appreciate the multiplicity of stakeholders that are involved in the equality and freedom from discrimination agenda and the synergies that need to be harnessed to deliver a just and equitable society. I want to pause here and mention that CAJ, or what you commonly call Ombudsman, those are our sisters. The Kenya National Human Rights Commission is another sister. We all come from the same kind of provision in the Constitution, and therefore we have to work together and deliver this big mandate. The National Gender and Equality Commission started its operations in 2012. I wish to take this early opportunity to thank the current and former commissioners and the Secretariat who have nurtured the Commission from its inception. I want to remember Lichuma, who set up what we call the Gender Commission today and put the structures on the ground. She's not here today, but I want to make a special mention of her. And the other two commissioners who are busy working, they are already in Uganda representing us. They will be with us next week, and therefore I want to recognize that they have done very well, and it is not easy to start a commission or any institution. So the members of staff here, and you can put up your hands, the members of staff, I want to make special mention because you are the champions. As we go to phase 2, we want you to be with us. I take office with a pledge to champion the interests of all special interest groups and position the Commission into an effective monitoring institution in ensuring compliance with the principles of equality and inclusion As
Present. Crispin Miguel. Present. Ms. Guto. Present. Mr. Paul Amunga. Present. Mr. Pravin Bauer. Honorable Millie Odhiambo. Honorable Anthony Onwatch. Mr. Alfred Ucheng Okeo. Mr. Fred Atuo. Mr. Paul Elkington. Ms. Rebecca Mogire. Honorable Judy C. Jane. Mr. Hiram Kago. Honorable Ben Momani. Ms. Carol Uday. For the second accused is my Lord friends, Mr. Maurice Kimuli. Present, my Lord. Mr. Paul Nyaosi. Present. Mr. Eric Mutua. Mr. Mumu Mutisia. Mr. Justus Munyidia. Present. Mr. Eric Kibuba. Present. Mr. Apollo Bwana. Present. Mr. Duncan Okubasu. And Mr. Ocheng Ogenga. For the prosecution, you know whether you have to present. Okay. We are taking a break.
Yes.
On behalf of the Republic, Dr. Sidon Secretary Prosecutions, Ms. Kamau Emily, Deputy Director of Public Prosecutions.
Secretary Public Prosecution.
Secretary Public Prosecutions.
Emily Kamau.
Deputy Director of Public Prosecutions. Ms. Gakobo Kwisi, Senior Assistant Director of Public Prosecutions. Mr. Kadebe Edi, Principal.
Sorry, Mr. Pardon, Mr.
Mr. Kadebe Edi, Principal Prosecution Counsel. Mr. Udimu Duncan, Principal Prosecution Counsel. Ms. Wangia Annette, Senior Prosecution Counsel. And Mr. Atula, Prosecution Counsel.
So the matter is now coming forward.
That on your screen is James Orengo, who is just speaking. He's one of the lawyers representing the accused, that is in the DCJ's case. And we've also seen an official from the DPP's office. But now let's cross back over to the Supreme Court where the Chief Justice is speaking. Let's listen in.
And appointments and even elective positions take into account both genders, which are mentioned in the Constitution. So it is your role to make sure that you play your part very well so that the Kenyan people can benefit from the provisions of the Constitution. You have rightly mentioned about the boy child. We have had, for a long time, we have had affirmative action in respect of the girl child. And in the process, we have sort of forgotten the boy child. I am happy to note that it has already concerned you, and you are going to carry out, to do whatever you can to make sure that both genders, especially our children, are taken care of, and the provisions are made so that they are not, neither is left behind. This morning I'm particularly delighted to note the appointment of Dr. Chomba. I want to congratulate His Excellency the President for this particular appointment. Why is it important for me to mention that? Because under our Constitution, and as we all know, disability is not inability. As a matter of fact, some of our brothers and sisters who have challenges here and there, by the grace of God, excel in other areas and excel very well, and do even better than those who are no such challenges. So, Dr. Chomba, I'm particularly delighted about your appointment, and I'm sure that you are going to make tremendous contribution to this commission. With those few remarks, ladies and gentlemen, I want once again to congratulate the new members who have been appointed, and urge you to carry out your constitutional responsibility for the good of our country. Let the entire country move together, and let us not leave anybody behind as we move together. Thank you very much.
Thank you very much, Chief Justice. We've come to the end of this event, and we will have a brief photo session just at the stairs. So we'll ask that. Okay, Chief Justice, the Secretary is just informing me that there is a special lunch for the newly appointed chair and members, and you're invited. They'll be pleased to have you. So we will just proceed to the stairs for a brief photo session, and then okay. So we'll just please make way.
The Chief Justice David Maraga has given a wide berth to talking about the issues of his deputy having been arrested and arraigned. And CJ David Maraga was overseeing the swearing in. He was presiding over the swearing in of the 3 members of the National Gender and Equality Commission: Joyce Mutinda, the chairperson, Murethi Chomba, member, and former MP Priscilla Nyokabi as a member as well. So we were expecting that he would speak about it and the issue of corruption in the courts, but he has not. But we hope that he could give a statement as the day goes along. Ken Mijungu is there and is going to follow up. Hopefully he can get an opportunity to get the President of the Supreme Court of Kenya to give a statement on the same. But for now, let's cross over and back to the Milimani Law Courts, where we have the ongoing session where the Philomena Mwilu is going to be taking plea on corruption allegations and charges. Let's listen in.
Attack on the entire judiciary. That's why you're seeing so many senior counsels here today. So that we are going to demonstrate that these proceedings are not necessarily a prosecution against the Deputy Chief Justice, but it is an attack on the judiciary. The criminal justice system has been weaponized to achieve an extraneous purpose and for an ulterior motive. Secondly, I'm just summarizing the grounds under which we want to address you and to seek then directions from you that you cannot proceed with this matter in view of the objections that we are raising. That on the face of it, looking at the charges, this is not a criminal prosecution, and when the evidence will be put before the appropriate forum, it will emerge that a contractual transaction, a purely commercial transaction, has been criminalized. And it's a transaction that took place more than nearly 5 years ago. So it is like a nuclear bomb. This is a nuclear option to look for any material that will be used to drag the Deputy Chief Justice into this trial. Thirdly, we are going to demonstrate that there is no factual foundation. There is no factual foundation for instituting these charges against the Deputy Chief Justice. Fourthly, we are going to demonstrate that these proceedings are an abuse of the process of the court, and that matters which naturally fall within the province of the Ethics and Anti-Corruption Commission, and every case, including the ones you have dealt with, were investigated and recommendations given for prosecution by the Ethics and Anti-Corruption Commission on the face of the charge sheet, although these are corruption-related offenses under the Anti-Corruption Act. This charges has been brought by the police, and we are going to demonstrate why the Director of Public Prosecution on this matter chose to use the Director of Criminal Investigations, who turned out to be user-friendly, as opposed to using the legal regime, the statutory regime that relates to offenses created under the Anti-Corruption Act, and for the purposes for which this court has been established as an Anti-Corruption Act. Otherwise, for normal penal code cases, we would have gone before court number 1. Finally, amongst other reasons which probably we may not need to advance for purposes of persuading Your Honor that this matter should not be taken, a plea should not be taken, is that despite the fact that this matters, the actual complaint of in the charge sheets took place nearly 5 years ago, in a space of 5 hours yesterday, both accused, the first accused was arrested. Taken to the Director of Criminal Investigations. And by 5 o'clock, 5:30, we are before Your Lordship, Your Honor. That is an unusual efficiency, very unusual. For those of us who practice in this court. Now, Your Honor, I want to persuade you that you should not be in a hurry. To require the accused person to take plea. And by that, I'm guided by the authority of a judge of the High Court, Justice Nyakundi. I'll give you a copy. My Lord, in my reading of the law in relation to taking of pleas, there is a case that is familiar to this court, Adan versus the Republic. I think there is no case that advanced the need and the process of a careful consideration of a plea, more than Adan versus the Republic. During the phase in which Kenya faced a lot of political headwinds, and people were being arrested and kept in custody for more than 60 days, brought to court at night and forced to take a plea.
At any one point, did you know that he was being investigated over the same issues that you are giving her responsibility for?
But she has been discharging those responsibilities since she came to the office.
Okay.
Yeah, she has. Those are. She's the person who is been performing the position of the judiciary ombudsperson. Okay. Yeah.
And don't you think by...
Leave it at that. I don't want to comment on matters that are in court. No. Thank you. Thank you.
What is the JSC?
Taking, the court has a responsibility. It's not a matter that should be left to an accused person. It's not a matter to be left to the advocates, but the courts also have a responsibility. My Lord, Your Honor, it may have been thought that we are better persons and more obedient to the rule of law and respectful the Bill of Rights, so that we had a case like Adan versus the Republic. But even during the colonial period, there was another case, Tambukiza versus Unyonga. This is before independence. A decision of the Supreme Court of Kenya, which later on became the Court of Appeal. In 1958, this is what this court is saying. Holding number 2. If I may invite you, are honored to look at holding number 2. The whole object of Section 89 of the Criminal Procedure Code and of the subsequent sections dealing with the framing of charges is that before a trial can be held, the accused must be arraigned before the court on a formal charge which must comply with the provisions of the Criminal Procedure Code. If there is no charge, then there is nothing in which there can be an error, omission, or irregularity. What the court is saying, that you must be satisfied that there is a charge. And in fact, it is for this provision section 89, subsection 9, you would then be required to admit the charge. The court is required to admit the charge after consideration of the charge. Your Honor, in relation to now the authority that I've placed before you, and I'm looking at page 6. Page 6.
Which one? The one of Tumbukiza or the one of
The one I gave you earlier.
Joshua Jiri.
Jiri passenger.
Page 6.
Yeah. Your Honor, I think this is a very important case for purposes of the development of the law, because it is saying that before a plea can be taken, an accused person is entitled not only to the charge sheet in advance, but is also entitled to the evidence before a plea can be taken. So looking at the material that has been given to an accused person as evidence and looking at the charge, an accused person can then make an informed decision as to whether to plead guilty or not to plead guilty. Your Honor, I want to persuade you that this procedure has very long history. In England, before the Magna Carta, there emerged a mechanism which found itself in common law jurisdictions, including our own jurisdiction, the idea of having a pre-trial process so that before you take an accused person to court, there is a determination as whether there is a proper charge and there is sufficiency of evidence. Not sufficient for determination of guilt or innocence, but to make sure that somebody is not being dragged to court on trumped up charges. So in England, imagine a practice which is there in the United States of a grand jury and a petit jury. The grand jury will look at the accusation and the evidence before the matter is taken for trial on determination by the grand jury that the state is not dragging somebody to court on trumped up charges. And the Honor would know that in relation to the capital offenses that are triable by the High Court, including murder and treason, formerly there were what are called committal proceedings that went before a magistrate, and the magistrate would make a decision as to whether there is sufficiency of evidence and a proper charge for the matter to be taken to the High Court for trial. Those committal proceedings used to be almost like a full trial. Justice Nyakundi seemed to have gotten the point that because we do not have a grand jury and a petit jury, he spells out what the accused person must be, what must be available to the accused person before a plea is taken. And he cites a case from Malaysia, which was adopted with approval in a Kenyan case. The relevant of the part of the part relied on in the judgment is found under the citation of those two cases. And if you may allow me to read what it says. If the right to be heard is to be a real right which is worth anything, it must carry with it a right in the accused person to know the case which is made against him. He must know what evidence has been given and what statements have been made affecting him. And then he must be given a fair opportunity to correct or contradict them. In principle, the evidence together with the charges must be produced in advance and supplied to the accused before he is called upon to answer. So this cowboy tactics that were mentioned yesterday of dragging somebody in the office, I'm allowed you already could see what they intend to give us as statements. The Deputy Chief Justice is supposed to answer to the documents you're looking at. Or a similar, if Now, for an accused person, this is what the Nyarangi is saying, Nyakundi is saying. Before you can elect to give an informed plea, you don't just need a statement of the offense and the particulars. You need the evidence so that you can say, okay, it looks like they got me on this one. So the best part is for me to plea bargain. There are provisions for plea bargain. Or outrightly enter a plea of guilty. Now, consequently, where an accused person, now she is talking about a conviction, where there has been a conviction. And goes through that if a conviction is entered in circumstances where there has been no sufficient opportunity to be given an accused person prior to an indictment, then those kind of proceedings would offend Article 50, Sub-Article 2 of the Constitution. The right to a fair hearing. Fair hearing does not mean dragging somebody to court. It means that the whole edict of the law must be adhered to. And then in the middle of this passage, it says, I can think of no possible rationale. This is a judge who rose through the ranks, and he's talking out of experience. I can think of no possible rationale at all why accused persons charged with various offenses are not allowed an opportunity to produce the charge sheet together with the witness statements before being invited to answer the charge. So what is the judge saying? That an accused person should get all the statements before the charge. And he says, this the court is doing because the court is the defender of the Bill of Rights. And that is contained in Article 19 of the Constitution. There is nobody, no person in Kenya who cannot follow the Bill of Rights, as read with Article 2, Article 10 of the Constitution. We are obligated So, Your Honor, one of the provisions we are going to address is the question of the rights under Article 50, sub-article 2 of the Constitution. And I'm posing the question, does Your Honor have the jurisdiction to hear and determine a complaint properly placed before you on violation of Article 50, sub-article 2? We are shortly going to give you an answer to that question. And that arises from the Magistrates Act.
You want to refer me to Section 8?
I'm coming to the Magistrates Section 8. Okay. Let me leave it.
But you can submit on it.
Yeah, but I want to submit on it because there's an authority here we want to refer to. Your Honor, the Magistrates Act, Section 8, does give the court jurisdiction to hear and determine applications for redress for denial or violation or infringement or threat to a right or a fundamental freedom in the Bill of Rights. But states that in subsection 2 of that section 8, that jurisdiction only relates to Article 25, sub-article B. At sub-article 25, A and B deals with torture and slavery. That is the jurisdiction that is granted before to this court. And that is normal. Even the High Court cannot step on a presidential petition, election petition. So all courts, including the Supreme Court, have jurisdiction which is created by the law. But while addressing that question of Article 25, it is important to note that the right to a fair trial is not derogable. And that means when a complaint is raised on the question of fair trial, it must be dealt with. But it can only be dealt with by a court of competent jurisdiction. Now, my Lord, the conundrum is that the Constitution says you must apply the Constitution, you must apply the law in making a decision. Every person, every state organ, including this court, must apply the Constitution. So when a matter is brought before you in which you have no jurisdiction, then in applying the law, you would determine and locate where that jurisdiction is and let the court with jurisdiction deal with that matter. And it's not any matter is a matter affecting fair trial, which is non-derogable. And non-derogable in circumstances where Article 19 give a constitutional fiat that the Bill of Rights is an integral part of Kenya's democratic state. So the moment we do not deal with that question, then you are undermining the very foundational principle under which this republic is established. So, my lord, what we are saying is that you should not hurry to take the plea. You should not destroy the file. But what you should be telling us, that since you have filed a petition, can you go before the court of competent jurisdiction to deal with that question? Once that question is answered, then you can come back with a determination. And the High Court has dealt with a question like this arising out of election issues. This is case miscellaneous civil application number 305 2017. It was an application by way of JR. The ex parte applicant was one Susan Kihika Wakarura. And the parties are there. But the provisions, the part of the judgment that I want to refer to you without taking too much time, is that from page 7 to 8, where the question of jurisdiction is addressed. Why the High Court? We want to persuade you to apply the applicable principles or propositions which are made in this judgment. And, my Lord, Your Honor, you note that in the judgment on page 5, paragraph 30, there's a reference to the case of owners of the motor vessel Lillian versus Caltex Oil Kenya Limited, and the law report, relevant law report is given a decision which has been unimpeached from the time it was made up to now, where the judges, and more particularly Justice Nyarangi, said, and this has been followed by the courts here, that jurisdiction is everything. You either have it or you don't, and if you don't have it, you down your tools. So we want to persuade the court that on this matter you are raising, we must down our tools. Downing tools is not taking away tools. It's not a sign of a derogation, but it's just downing the tools. And Your Honor, the commentary by Justice Odunga in this matter, in paragraph 37, 38, 39, 40, and this is a matter in relation to a tribunal, and he was saying that even if the tribunal had to apply the Constitution, he can only apply that Constitution or interpret that Constitution in relation to a matter in which the tribunal had jurisdiction. So we are saying that this is a matter in which you do not have jurisdiction. Now, the other issue that we are raising, which I put out in summary, is that Chapter 6 of the Constitution is a very important creation an innovation in our Constitution, which talks to matters integrity, leadership and integrity. Now, under that chapter, Parliament is directed in Article 79 to enact legislation to establish an independent ethics and anti-corruption commission, which shall have the status and powers of a commission under Chapter 15. And my Lord, if you look at Article 249 of the Constitution, particularly 249(2), the commissions and the holders of independent offices are only subject to this Constitution and the law, are independent and not subject to direction or control by any person or authority. There's a constitutional requirement that the Commission shall not be directed or controlled. My Lord, if you look at Article 157 of the Constitution, which relates to the powers of the Director of Public Prosecution, it says in Article 4, Sub-Article 4, the Director of Public Prosecution shall have power to direct the Inspector General of the National Police Service to investigate any information or allegation of criminal conduct, and the Inspector General shall comply with any such direction. So under our constitutional arrangement, the only person or office that the Director of Public Prosecution can direct or give orders in respect of investigations of a criminal conduct is the Inspector General. Now, unfortunately, for the Director of Public Prosecution, if you look at the charges in the charge sheet, they relate to offenses provided for under the Ethics and the Anti-Corruption Act. Yes, and Your Honor, just to address this point, the statute which talks to the creation of the commission by an act of parliament enacted in compliance with Article 79 of the Constitution, Section 28, the Ethics and Anti-Corruption Commission Act, says, and it speaks of independence of the commission, except as provided in the Constitution and in this Act, the commission shall, in the performance of its function, not be subject to the direction or control of any person or authority. So the case that we want to make, which is about abuse of process and lack of fair hearing, is that the Director of Public Prosecutions capriciously, malafides, and with ill motive has taken these matters to the Director of Criminal Investigations because he knows that that's where he can give directives as opposed to the Commission. And the proposition that we want to advance to your honor is that insofar as the chapter dealing with leadership and integrity in the Constitution and the enactment of Ethics and Anti-Corruption Commission is for purposes of dealing with matters that relate to corruption and the economic crimes, which we all agree must be dealt with. But because they relate to public officers and state officers, in order to ensure that not every accusation that is brought on board is rushed to court, offenses that relate to the Ethics and Anti-Corruption Commission are to be investigated by that commission. And they do that without direction from anybody. The functions of the commission in the Act, the Ethics and Anti-Corruption Commission, is found in Section 11, 1D. In addition to the functions of the Commission under Article 252 and Chapter 6 of the Constitution, the Commission shall investigate and recommend to the Director of Public Prosecution of any acts of corruption or violation of codes of ethics. So the Director of Prosecution was telling the Commission, don't waste my time. I'm going to deal with this my way. But the law does not allow him to do it his way, because the Ethics and Anti-Corruption Commission Act has a full regime. Code of law that relates to investigations, particularly to the offenses which are created under that act. Section 45, 46, and so on, are created under the Anti-Corruption and Economic Crimes Act. What is important in that? It is important, first of all, you would notice that the commissions are given the power of the police. They can investigate, they can arrest. There are many other alternatives, mechanisms, asset seizure, requirements for explanation of assets. And because this has got to do with integrity of public officers, Section 33 requires that no person except with the leave of the director or with other lawful excuse disclose the details of an investigation under this act, including the identity of anyone being investigated. Now, everybody in Kenya knew that the Deputy Chief Justice was being investigated before even the director talked about it. You can see headlines. She has fallen. How is this information getting out there before even the director of public prosecution has said anything about it? This is the protection that was put in this act to ensure that whereas we require our public officers to be guided by the dictates of Chapter 6, in doing so, they should not be bashed around. Which is what is happening in this matter. With respect. And at the end of the investigation, what is the commission required to do? Section 35. Following an investigation, the commission shall report to the director of the public prosecution on the results of the investigation. 2, the commission's report shall include any recommendation the commission may have that a person be prosecuted for corruption or economic crime. Now, this is an economic crime. Corruption. You can see the sections referred to basically falling under that act. And the work of the commission is subject to quarterly reports which have to be given to Parliament, to the President, for examination so that they are accountable in some form or shape. So we are saying under the circumstances in which the Director of Public Prosecution has cherry-picked which institution to use for the purposes of this case, we are saying it is not for nothing, it's for a malicious purpose, it's malafidis, and it's to deny the accused persons an opportunity to confront even the allegations that have been made. Your Honor, for example, in count 2, we have an answer. To show that whereas the accused number 1, through the lawyer, gave a professional undertaking to pay the loan and replace a title after a discharge. The lawyer gives 2 undertakings: pay the money, give an alternative title. The bank does not wait for that. As soon as she has paid 65 million, he says, have your title. I know Malan friends with respect would say that's the matter of evidence, and I'm saying it purposely because that is the evidence we want to place before the High Court to show that these charges are a sham. And Your Honor, while at it, I want to share, and I'm not seeing this as an authority, as it were, but one of the most famous judges in America in the Supreme Court was a judge by the name Justice Frankfurter. He served in the Supreme Court. Justice Frankfurter. His name is spelled Frank and then F-U-R-T-E-R. Him and colleagues in the Supreme Court were involved at a time when the United States was dealing with a war situation, the Second World War and the war in Korea. And the executive felt, the President, Truman, felt that in a war situation, the executive can do anything in defense of the country. They even took possession of steel mills. They said, we want to produce weapons. And these companies are not doing it fast enough. We are taking over these steel mills. So the words of Frankfurter that I want to share with the court, he says that dangerous power which is accumulated by a government or a state organ does not come in one day in a single stroke. It comes slowly. From a force that he calls regenerative. And is a force of unchecked disregard of restrictions. The law places some restrictions, some which are very small, but slowly. And we have that experience in 1980s. Slowly you come to a court, even to get bail. You're told bail is not a right if there's a question of state security. You know, there was that kind of dubious, postulation at that time. And it was coming slowly. And judges who tried to check it, some of them suffered. There's a judge called Schofield. And you know what I'm saying is that what the DPP is doing is a disregard of a law that is useful to him, because ultimately he is the one to carry out the prosecution. And he goes to the wrong institution. And we're saying that is for an extraneous purpose which has nothing to do with the objectives of the criminal justice system. For example, Your Honor, yesterday, I was very happy yesterday when you said, why do you bring an accused person at 5 o'clock? Your Honor, in 1980 it started like that and everybody was being brought to court at 9 o'clock. The working hours were there those days. Official government hours were there. But because the state slowly had been allowed to take people to court, at 6 o'clock, then they come at 7, they come at 10 p.m., it became the practice. Yesterday, I went home smiling. Because you could see and read the mischief. And there was no explanation for that mischief. Even that fact alone yesterday for bringing the Deputy Chief Justice to court at 5 o'clock, beyond 5 o'clock, is an exemplification of the malice. Your Honor, we are therefore saying in conclusion, we have raised issues about these pleadings, about these proceedings in relation to Article 50, Article 27, Article 28, 27, which is the equal protection of the law, protection and benefit of the law, Section 50, more particularly Article 50, and more particularly Article 2. And in Article 50, we are dealing with more than 5 violations and infractions. And then the right to dignity, Article 28. Those are not matters in which this court has jurisdiction. And the other, I want the court to take judicial notice to what has just happened today. Cases that have just dealt with. They are not even hearing dates. People they are brought here, they are not hearing dates. So why should we be in a hurry when there is a serious constitutional question of a matter of a violation? Is the date more important? Or is the trial more important than respecting the rights? And to ensure that the powers granted or donated to the Director of Public Prosecutions are not used in abuse of Article 157, sub-Article 11, that requires of the Director of Prosecution to ensure that the interest of the administration of justice and the need to prevent and avoid abuse of the legal process is protected. We have made that allegation directly against the Director of Public Prosecution. And the same Director of Public Prosecution, whom we have accused, just like they have accused us, wants to try us before we determine that question as to whether they are acted within the law in regard to these proceedings. Your Honor, since we are raising these objections orally, and even given time yesterday, they would have done it, because the courts have said these objections should be raised at the earliest opportunity. And there's no format or legal regime that we are required to fulfill when such a matter is raised before the court. And I want to persuade Your Honor to allow us at the end of submissions to avail the case of Jared Pangwara versus the Republic, with which the prosecution is very familiar. Where Judge Hamoni was saying that in dealing with a matter in which an allegation of abuse had been raised, as opposed to a challenge to the charge on the face of it, the court would require to look at evidence, and in his words, as he was examining the evidence that was placed before him, he said that he was examining the evidence not to make a determination of that case, but to look for this thing called abuse. In fact, I kept use the word thing. I'm looking for this thing called abuse. And in that Justice Kangwana's case, he was looking for that thing. Given the opportunity, Your Honor, to put this matter where it belongs, we are not going to be looking for this thing. We are going to be looking for these things, because there are many. And that thing will include the constant and persistent attack on the Deputy Chief Justice on account of seeking her removal. And for that, there is another matter that again we want to avail to the court, the case of Joho versus the Republic, where the court, and this is the High Court, looked at the circumstances and the context in which an intended prosecution was being brought against Governor Joho. And in that case, he was able to demonstrate that there were a series of incidents, including utterances by public officers and state officers in the executive, that to that court showed that there was an extraneous motive. And even a cursory look at this petition that we have filed, courtesy of the work the council have done over 6 hours, the things that are related here in terms of evidence which we cannot, because of lack of jurisdiction, present before you. But I'm saying this is not an idle complaint or violation. Of the rights of the accused person under the Bill of Rights. So I would want to persuade Your Honor that we defer the plea the Deputy Chief Justice, on the basis of the personal recognitions she signed yesterday, appeared again today at 8:45. And whatever directions and orders the court may make in terms of these proceedings, we would be able to comply while awaiting the determination by the rightful organ of the judiciary, which is given jurisdiction. And whatever the outcome of that case, we will come before you, Your Honor, for you to make the final orders, that question having been determined. Your Honor, with your permission, I would ask, because we are a big team, not all of us are going to address you. Dr. John Haminwa will say a word, and His Excellency Stephen Kalonzo.
From your team,
yes.
How many other people are going to address now?
Those, me and two others.
Only you and 2 others.
Yeah.
I'm sure you're not.
And then at the end of it, as lead counsel, you give me just a minute now to tie the loose ends. Yeah, you want to start? Yeah, and His Excellency will start.
Thank you, Your Honor. I wish to concur with the very able submissions made by Senior Counsel Jim Orengo in this matter, which is of great national importance. Because it does go, Your Honor, to the core issue of integrity within the judiciary, including its independence. Of course, the prosecutor here will have noted that it was an oral application. And I just want to stress the provisions of Article 50, Sub-Article 2 of the Constitution, as ably elaborated by Senior Counsel. I say the right to a fair trial of any citizen is basic. That under our Constitution 2010, we as a country can pride ourselves in having strongly addressed the matter of what is actually contained in the UN Declaration on Universal Rights. And these fundamental rights cannot be derogated. And I think there's also an issue of decorum, Your Honor, without necessarily feeling that we do not recognize the very important role that this court is playing. Indeed, happy with the decision you took last night, that the Deputy Chief Justice, considering herself equal, because it's a principle of equality before the law, but that notwithstanding, you're dealing with the person of the next in command of the entire judicial system. And therefore, I wish to add that giving this matter time is not an act of indecision on your part, Your Honor, but a recognition of the critical importance of this whole issue. While all of us accept that the fight against corruption is important, indeed is timely, but we cannot take that as a panacea to literally roughshod rights of important state officers, because therein lies a challenge that is before us. I therefore want to concur and ask that, submit that the first accused may not be called upon to take a plea at this stage. Thank you.
On a light note, may I say good morning?
I want to give you a few
You want to?
very few minutes.
Very few, I appreciate it.
Please take, not take a lot of time.
Yes.
The lead senior counsel James Orengo has submitted extensively on this matter. I'm sure you know when you study, you can get quite a bit of time. Please just keep yourself.
Your Honor, may I say to you right from the outset, the purported arrest of the Deputy Chief Justice took the entire city and the entire republic, particularly the past. For the simple reason that we construed this to be a direct attack on the independence of the bishop. The 2010 Constitution, for which we fought, for which we were detained, some people were assassinated, brought a regime into force in the country to protect the independence of the nation. Apart from the independence of the judiciary being protected by our Constitution, it is also protected by international covenants. The United Nations resolutions of 1985 do set out very clearly and emphasize that the judiciary must be protected, must be independent. In those provisions of the United Nations, there are provisions that relate to disciplining of judges for any misconduct. It's also emphasized in the resolution, the provisions of the United Nations, that those that are responsible to discipline judges must be independent. In our own Constitution, that has been provided for. We have Judicial Service Commission, which is supposed to be independent organ. And if there is any issue relating to disciplining of a judge, the Judicial Service Commission must be given the opportunity for its input. It will then recommend a tribunal to be set up by the President. When we come to the case of our Deputy Chief Justice, nothing of the sort was done. The Judicial Service Commission was not invited to make any finding or to hear her case. Your Honor, my humble submission that on this score alone, you must decline the invitation for you to take a plea in this case. Our internal provisions in the Constitution that protect the independence of a judge have been violated. My Lord, we also, Your Honor, we all want the issue of corruption to be dealt with. But that must be done within the framework of the Constitution. It must be tackled within the framework of statutory provisions. Your Honor, if that is not done at all, we shall have rogues and crooks with power dragging our judges into courtrooms, dragging into our magistrates into courtrooms on trumped-up charges. which have no meaning, which have no validity in law at all.
Jochaminwa, who is also giving some of his submissions, and we earlier saw Orengo speaking, as well as the former Vice President, Kalonzo Musyoka. Interesting that some comments here ongoing are that he was once a Vice President, now he's in a magistrate's court defending the DCJ, who's also taking other steps to ensure that her prosecution does not go. We shall be giving you the details and more from our different locations like we had promised as we take a break for now.
System, we go by hierarchy. I am a mere advocate, nothing more than that at all. I'm expected to pay my respect to you as a magistrate. And you are a magistrate. You are expected to pay respect to a High Court judge, or judge of Court of Appeal, or judge of Supreme Court. You have been put in a very embarrassing position. I would not like to be in your position at all.
Restraining yourself from making some political statements.
We are
kindly confine yourself to issues of law.
Yes.
Yes. Please do not go political because I'm not able to respond
You
to
know,
that.
I take note of what you have said. I do not wish to say much more. I would just like to say that it seems that certain individuals somewhere are trying to interfere with our independence of judiciary. One final word before I sit down. I appeared in the case of Nancy Baraza. I was in counsel. Nancy Baraza was accused of a very, very trivial allegation. But she had to go. I again appeared in the case of Justice Rawal, who was set to become Chief Justice. It was an issue of age. endorsed that case. And when I left the Supreme Court, I was a bitter man. I said a few things that should not probably have been said.
But the Supreme Court nevertheless made the decision.
Now, this lady has been brought here. Now,
Yes.
I want to say a few things to you. This is a time when you have to say a few things. Please, just excuse me.
Yes.
Yeah. It seems that some people somewhere, when they want to change the judiciary, they want to change officers, they want to see themselves as chief justices or deputy chief justices, they go out to attack the women judges. She's a victim. Let us give us the opportunity to argue this case before the High Court. And we shall demonstrate to the High Court of the whole country that these judges against this lady are malicious, vicious, spiteful. They have an ulterior motive. And there are certain individuals who are a party to it. They involve lawyers, advocates, they involve certain individuals and so on who want to have regime change in the judiciary. That is what it is. Well, you may excuse me, I have another matter before the court if I may leave. I'm not leaving out of this country.
All right.
You may allow me to.
You are discharged. So, Mr.
Kimuli.
Kimuli, for
Your Honor,
the second
for the
accused.
second accused. From
So,
the
yes.
outset, Your Honor, I associate myself fully with the submissions of those who have gone before me. I confirm that the second accused person, the second suspect, I think we need to alter the nomenclature. The second suspect, because they have not taken plea, is part and parcel of the petition now before the High Court. And I was privileged to sit with Honorable Jim Orengo, and at 3 a.m. I looked at his eyes, he dozed not. And that must account for something. I think it must be your passion for justice. Your Honor, my client, as I stated yesterday, is an advocate, a member of the bar. And therefore, this question, this matter, Your Honor, not only affects the independence of the judiciary, it also impinges on the independence of the bar. The second accused person, a young man is in 30s, who has through professional conduct earned the respect and confidence of none other than the Deputy Chief Justice as her lawyer. Is brought to court as a victim of circumstances. And this is what my client is protesting at the High Court. I'm reminded that he is collateral damage. There are those who would like to get at the Deputy Chief Justice. I do not want to speak about that. It has been mentioned here. But my client, Your Honor, has no dog in that war. He represented a client. If they had made allegations against the Deputy Chief Justice alone, the only witness he would have called is my client to say, hey, look, how do you say this was not done? I'm the one who did it. How do you say stamp duty was not paid? I'm the one who paid. How do you make this allegation? I never got communication from the other side. Now, the only person who would be a key witness, who would have changed the narrative, when they say the Deputy Chief Justice has done this, somebody changes the narrative by saying, I have the facts. That person is intended to be made a co-accused, so that he can be humiliated, and so that the absurdity of the Deputy Chief Justice having to call as witness a co-accused is held out for all to see. My client has gone to the High Court for good reason, Your Honor. Allow me, Your Honor, to tell you that you sit here today as my client's first line of defense. And under Article 50, Sub-Article 2, my client is entitled to protest his innocence through all lawful means, including addressing Your Honor as I do this morning, and including approaching other courts as permitted by the law, which he has done. And what he's asking you to do this morning, Your Honor, is to permit him an opportunity to ventilate his misgivings about this process before the High Court. And the process has already started.
Basically, what you are saying, the first point is that we should not take plea because there is already an application before the High Court.
There is already an application before the High Court.
So you have made that point. And
yes.
Let's move to something else.
Yes.
Because I think that one you have submitted quite at length from the beginning.
And I had already cleared that part of Your Honor. I was moving to my next point.
All right.
Your Honor, when you look at the High Court, Your Honor, there may be an argument that it does not hurt to take plea. You will be allowed to defend yourself. This is an argument, Your Honor, you may have heard far too many times. That plea is not an end in itself. Challenge the evidence. But Your Honor, I urge you, as you retire to make this decision, this ruling, to consider the effect of a plea. It changes you automatically from being a suspect to being an accused person. It changes the way people look at you. An unnecessary plea is an unnecessary burden. And I urge you, Your Honor, as a gatekeeper in our fabric of justice, not to allow pleas that must not be taken. And particularly where a party informs you, as we have done this morning, that they intend to use another avenue, perhaps before coming to you, if it must come to that. And there will be absolutely no prejudice, Your Honor, to be suffered by the prosecution. And I believe the prosecution must be doing this on behalf of Wanjiku and Musangi. The proceedings before the High Court, Your Honor, mention the Director of Public Prosecution as a party. It also mentions the Attorney General, and it also mentions the Director of Criminal Investigations. In a sense, therefore, Your Honor,
so the proceedings in the High Court
mentioned as respondents the Director of Public Prosecutions,
yes,
the Director of Criminal Investigations, and the Attorney General.
3 offices.
Yes, they also mentioned the Office of the Chief Justice, but that is represented by the...
Even the Office of the Chief Justice is a party.
And maybe, Your Honor, my learned friend.
You know, I made a full disclosure at the beginning.
Yes, but you see, you did not give
there were proceedings going on in the High Court.
You only mentioned that there is a petition in the High Court.
Yeah.
You did not exhibit it to the court.
Yeah. The High Court
Yes.
has stayed these proceedings.
As we speak.
Yeah, as we speak. That's
So-
why Mr. Kongo.
So where is the order?
And if Mr. Drobo was to address you, it would just be a waste of time.
That's what he was waiting for.
Yeah.
Do you have the order with you?
The order is coming. We can be able to.
So we proceed
We can
until I
adjourn
see the
for
order.
10 minutes. You see.
What I'm saying is,
Or we can proceed. Yeah.
What I'm saying is,
Yeah.
I
You know,
wish
there's an order of the High Court.
if you have the order with you, serve it.
Yes,
Give it to
that's what
me.
I'm saying. Give us an adjournment of 15 minutes. Just 15 minutes. We have not even had a little break since we have been sitting here since. But it just
Dorcas as well. There is that new development which we are told that is on the way. What is your response to that?
May it please Your Honor, as we speak now,
Yes.
there is no order that has been served before this court staying these proceedings.
Yes.
And whatever we brought before this court is within the jurisdiction of this court.
Very well.
But you can realize since this morning, we knew very well that the advocates for the defense, for the accused person, were waiting for something, and that is why they were taking us round and round and round. Now that it has come, they want us to go for a health break. Before then, they did not want. With
All
due
right.
respect.
As far as I'm concerned, the court is still in session. We will continue. Proceed, Mr. Kimu.
Yes, Your Honor, I
Please,
only
let's
had
have some silence, please. Let's have silence. Proceed.
At least he can proceed until it comes.
Yes, let him proceed.
Your Honor, since I'm still on my feet,
Of course,
Your Honor,
even when the order is served, I will also
Yes.
give an opportunity to the state to respond even to the order itself or something like that. So don't worry, just proceed.
Yes, Your Honor, I had stated that the key parties who have been the main actors in this matter are parties in the matter before the High Court. As such, a stay of these proceedings, deferment of these proceedings, deferment of plea, will not prejudice the prosecution. They will have an opportunity to confront the arguments before the High Court. We're not suggesting that we are going to be engaged in our own act, separate from them. We are going to be with them. And lastly, Your Honor, as I sit down, I invite you to have at the back of your mind the reality of what is happening around us. Even when you look at today's headlines, Your Honor, you will note that the Director of Criminal Investigations has suggested that there needs to be established special courts, which he can take his people to. It's in the headlines. He doesn't even know that you exist. He doesn't know that you are a special court for this purpose. He desires to have a court that can work better with his expediency. You'll also see that finally, the DCJ has fallen.
Who is your client?
Your Honor, I was finishing at this point, and I was making a general comment. I urge Your Honor to consider that while dealing with the question of the independence of the judiciary against the proposed charges, take judicial notice of the fact that the fire alarms are now ringing. There has been a systematic attrition on the independence of the judiciary which has constituted declarations made by people in high office, cutting back on the budget of the judiciary, and now they have gone for the generals in the judiciary. Now, when the generals in the judiciary fall, the rest of us will have nowhere to hide. It's a notice to everyone that if we can shake your tallest trees, we can surely cut down the shortest. Your Honor, I urge you to strike a blow for the independence of the judiciary and the rule of law. And particularly speaking at a personal level, the independence of the bar. Sooner or later, all of us, Your Honor, will have nowhere to hide. So respectively, Your Honor, I urge the court to defer the plea, pending the outcome of the hearing of the petition before the High Court, which has now been disclosed and which I'm sure shall very soon be served upon the DPP.
I think I'll invite the state to respond now.
May it please, Your Honor? Before I respond, I would need directions from you.
Yes.
Because issues were brought before you as objections, and at the same time, you were being informed that you have no jurisdiction to listen to them. So I do not know whether you are required to make a determination of them. Secondly,
Sorry, issues were brought before you as?
Before you
As objections.
as objections, and at the same time, you were informed or warned that you have no jurisdiction to deal with them. Secondly, issues were raised before you. We were not informed under which law, under which legislation, until the end, when it was stated that they are brought under Article 50, 19, and 29 of the Constitution.
Articles?
50, 29, and 19. That's what I had. Third,
Yes.
there has not been any submissions regarding the powers of the Director of Public Prosecutions under Article 157 of the Constitution, insinuating or claiming that he has no powers to institute these criminal proceedings. And Article 157 is very clear that he institutes criminal proceedings against all citizens of Kenya and in all courts except the court-martial. And entities, everybody who succumbs to the jurisdiction of the Republic of Kenya. In doing that, the Director of Public Prosecutions is required to act in the public interest, to protect and uphold the rights of the citizens and everybody, and also to prevent the abuse of process of court. Criminal proceedings are against a specified individual, person, or entity, and in this case, the criminal proceedings are against an individual. There are no proceedings that have been brought by the Director of Public Prosecutions against the judiciary of Kenya, and there are no proceedings against the Law Society of Kenya. The Director of Public Prosecutions, when making this decision, was satisfied that there is sufficient evidence and it is the public interest. And the sufficiency of evidence was ventilated through the lens of a prosecutor, fed by the investigator. And in upholding the rights of the accused persons that they are presumed innocent, that is the reason why we are in court to test the evidence that we brought before court, and the court has a right to make a determination at the end of it. The directions that we seek are there is no application or submission before the Honorable Court that you have no jurisdiction to deal with this matter. Secondly, there has been no objection to the charge as required under Section 89 of the Criminal Procedure Code. And we'll be seeking directions whether or not you'd want us to respond when there is no application against your jurisdiction in taking pleas and no objection has been raised as to the form or quality of the charge. And finally, I wish to state that as we speak about the Director of Public Prosecutions, and placing before this Honorable Court all these contorted insinuations, we must remember that he appears on behalf of the Republic, and the Republic includes everybody, even the Defense Counsel, you are the Honorable Court, the media, everybody. He represents everybody. The Republic is everybody. And when we act in the public interest, the advantages accrue to everybody, even the accused persons and even the Defense Counsel and everybody in this Republic. And therefore, when he's exercising his powers under the Constitution as an agent of the executive, he can only be interfered with or stopped as required by the law. And my senior learned friends, the professors and the doctors, are right that they have a right to go to the High Court or the Court of Appeal. That is their right. But when it comes to this court, they must also succumb to the jurisdiction of this court and deal with this court as this court. And if the High Court deals with the matters and issues an order of stay, we shall comply. In totality, my submissions are to the effect that, as far as I'm concerned, no objections were raised as to the jurisdiction of the court to take plea, whether the charge is in conformity with Section 89, and there is no provision that a magistrate should not be in a hurry to take a plea. it would be abdication of your duty to put that as a ground for not taking this plea. With those few remarks, I would seek your directions whether or not you want me to respond to the submissions that were made.
Your Honor, probably that would be a convenient break to give, with respect, I have done some matters with Mrs. Dorcas Oduor, very formidable opponent, but today she has been lost for words. She is completely lost for words. Yeah. So in the circumstances, what I pray, instead of again engaging in a response, which I'm prepared to do, we take a break for 20 minutes at most. And I'm told the High Court has said if you want the file to be brought here, they can make it available now.
Where's the order?
Yeah, with the order.
Where is it?
Yeah, they're being extracted. They're extracting the file, but knowing the urgency of the matter is being held during vacation. They know the, and Councillor Mogeni is here, and he's on record in this matter. He's an officer of the court. So anyway, we're subject to your direction. If you want us to respond to submissions,
I've not submitted.
we can, yeah. But she says she has not submitted. So I think for the convenience of everybody and order to save time, 20 minutes. She'll come and respond. And then we will also reply.
The state, through Mrs. Dorcas Oduor, this is the decision of the court. The state, through Mrs. Dorcas Oduor, has raised a number of issues that it seeks the court's directions on before responding to the objections made by the defense. At this point, the court directs that it shall take a brief recess of 20 minutes before reconvening with an appropriate order for directions.
We
All right, the court takes a recess for just a bit, and as you can see, the breaking news is that the High Court has stopped the prosecution of the Deputy Chief Justice, as Philomena Mwilu, who went to the High Court to seeking some clarifications, just trying to get it blocked based on some constitutional questions. And Justice Chacha Mwita has put it off until the 9th of October, and we shall be following up because that was part of the discussion that was happening in the court, where the counsel, that is James Orengo, was arguing that they have gotten the orders, the stay orders from the High Court, but the argument was that the prosecution said it had not received them, as well as the judge says he's not received it. So they've taken 20 minutes off. Then he says that the magistrate says that they're going to come back with the appropriate action, and we've seen a number of things being brought up as this being an attack on the judiciary, and there was some plea and call and push to have the judge shield the sanctity of the judiciary in light of what the lawyers of the accused are saying is an attack on the judiciary, and it is almost taking a political turn. We've seen a number of lawyers and leaders who have been aligned to the opposition there, and it is not necessarily that we're saying it's because they're in opposition, but we've just seen that a number of them are there. We've seen Mutula Kilonzo Jr., that's the senator of Makueni. We've also seen Kalonzo Musyoka, who's the leader of the Wiper party, and he actually spoke for a bit there. We've seen a number, and James Orengo, who's the lead counsel on that side, and so we've seen the state has also try to put up a fight on the same, and so we shall be giving you those details in not too long. Once we get them, in about 20 minutes, we expect that the judge, that should be at about 12:50, a few minutes to 1 p.m. that is, or thereabouts. The magistrate is meant to come and give some clear directions after the High Court has stopped the prosecution and raised issues on some of the constitutionality of some of the issues therein, and we shall be getting various views and feedback on the same from different people across the country when we get them, and they shall all be compiled properly in the course of the day and onto our bulletins at the prime time bulletins, 7 and 9 p.m. And just as we continue with this, just to close the conversation in studio, much as we've seen this, it's been delayed, rather it's been stopped for a bit. We've seen the High Court we've gotten the report that the High Court has actually stopped the proceedings, and this brings a question. It may not be the exact case, but generally we've seen a number of cases being adjourned and that kind of thing happening. What usually is the ripple effect when cases last too long before they get, and now I'm talking about even on the economic side, because ultimately that is where the buck will stop. Because or is that the case where you have a case is taking too long to be cleared, that it will have an effect on the economy?
There is a case about people who've raised cases that court cases take quite a while, especially corruption cases. Now, the economic bit about it is that there are resources that go to these cases, especially in terms of public prosecution. There is public money that has gone into. So if you expedite a process in terms of corruption cases, your conviction rate will be much easier. There is the reflection that the courts are working. There's a perception that the courts are working. And so it gives a gravitas to the fight against corruption. Another thing is that in terms of the economic side is that when you employ quite a number of resources when there is a delay and you're putting much resources in those cases, it means that it gives the impression that you're trying to shoot many positions to get a one shot. So it gives a perception that things are not working. If you talk about recovery of assets, there is a conviction and all those kind of things. It takes a while to get that. So there is that perception that court cases need to expedite it, and then the CJ at some point say that anti-corruption cases will be given priority. So we are yet to see that, but the public perception should be that, and the public reflection should be that, and anti-corruption cases should be expedited. So it becomes a perception that the gravitas of the fight against corruption is working best for everyone.
Okay, and we've seen a number of cases where we have governors, like we saw the Busia governor having been arrested, and we've seen former governors. But speaking of sitting governors who we've seen being arrested on corruption cases, what does that hold in store for the economy of that county, for instance?
Legally, in terms of the legal basis, is that there is no vacuum, even if he's arraigned in court, because there is a deputy governor, and the functions are that it's not a personality function. There are systems in place and all that. Now, the biggest question will be when you have such a case, when you're sitting governor, is that you might lose public trust with the people that you lead in that county. So in terms of public perception, in terms of rolling out projects, there will be that cloud hanging around that people won't trust the projects that you are trying to push. And so it becomes difficult to gain the public trust. And that's one of the biggest things in terms of public investments. You need public perception, public participation, which brings public trust. So that's one of the things that we talk about integrity within an office. So you hold a public position with so much integrity. So those are the things that we talk about integrity. You're able to build confidence even when you're rolling out projects. You look at Makueni, the way they've structured. The governor himself has put so much effort in terms of integrity, in terms of processes. There is transparency, there is open sourcing. So it rolls out projects very quickly, and you can see that this is one of the counties that is doing best among the 47 counties we have.
Okay, and one of the things that you've been seeing when we talk about the judiciary, and that there's been a lot of calls for, right from the Chief Justice, more funding to the judiciary, because they want to build courts, build courts closer to the people, because some people have to travel long distances. It's an inconvenience. It's a cost, even economically, be it on the micro level for the individual or even on a larger scale. For those who may not understand, what is the value of having the court there, I mean, in terms of for their economy?
Okay. Judiciary itself is where people go and seek a legal opinion or an advisory on the way forward. In terms of the economic basis of it is that if you have an issue, that the last expositor will be the judiciary. So these are institutions that need to be strengthened. And in terms of solving issues, in terms of legal basis, in terms of contractual issues, you will need to have a strong judiciary so that you enforce these laws, you enforce contracts and such kind of things. In terms of funding, there is a very good case about judiciary needs proper funding, because among the three arms of government, it's only the judiciary that has the best record in terms of using proper public funds properly. You look at the slashing of the budget that the CJ talks about. He has a good case that needs to be looked at by Parliament itself and the executive, because you cannot say that judiciary will get 15 billion and the same arm of government, on the other hand, is Parliament gets 39 billion. You talk about executive is at around a 1 point something trillion. So in all honesty, I think the biggest person who can help the judiciary is the executive. They can scale down a little bit of project and try and empower this institution of the judiciary.
And how far do you think Kenya would be if we didn't have corruption?
Definitely we'll be far. We've been having corruption as part of our DNA post-independence. We will be very far. Corruption came as a transition with the colonial system. And so if we talk about corruption in Kenya, we talk about pre-independence and post-independence. Post-independence is around 54 years now that we are independent. So 54 years.
Yeah.
So we talk about 54 years of misuse of public resources, abuse of public resources. These are resources that will have built institutions, will have built
55.
Yeah, 55 years. You talk about, one of the things I was arguing with somebody is that you look at the projects, especially schools, that were done by the colonial system, and you look at schools that were done post-independence. A big number of schools that we have today were done during the colonial period. Those are the schools that still stand. You look at the schools that we did on our own part after independence. There are very few schools. And the opportunity cost of that is that most of these things were embezzled. You talk about land, school lands, they're grabbed. You talk about hospitals. Most of these things that are allocated for public infrastructure projects were embezzled. Now, you find that there are little resources that even government will want to roll out projects. So the biggest opportunity cost that we have with corruption is that we are quite behind as expected in 1963 vision when it got independence.
Okay. And the other big issue that we deal with here is debt.
Yeah.
And talk about our national debt. Yeah. Do you feel that if we did not have as much corruption, we would have been a better place with debt, because a lot of the money is leaking into people's pockets as opposed to going into projects, which then means that we go and borrow more?
Yeah, there is a correlation that when Jubilee administration came in 2013, they rolled out a strategy to roll out big infrastructure projects. Now, these big infrastructure projects, we couldn't fund it through our revenue collection, so they opted for debt. Now, the consequences of that is that first, you need to have, those projects need to be very economically viable, that your returns get quickly, very, very fast. Second is that you have to be very efficient in how you manage your resources. That's where we failed. So there's too much leaking of public projects, the money from public projects. And so these are taxpayers' burden. So a taxpayer pays for a project which he is yet to see the returns of it. And that's the biggest question that as we continue borrowing, that is the biggest question that a taxpayer asks. We are not seeing the return on investments of this project. So why are we taking this debt? Those are the loopholes that we need to seal as per today.
Okay, and I'm just looking at some feedback online. I'm seeing Joy Mdivo, who's an advocate of the High Court. She was actually meant to be, she was one of Trevor Mbije's panelists on the other side, saying, this looks like an attempt to intimidate the plea-taking court. One advocate could have made the oral application and let the court make a determination. This wearing down strategy is effective in overwhelming the judicial officer. You see, they've brought all the big guns. They've brought Orengo. Kalonzo himself was there. We know, we've seen Haminwa there. We've seen a number of the, top lawyers, so to speak. And it's almost like, and it's a magistrate's court. Much as it's, anti-corruption was a magistrate's court, it's almost intimidating. Could that be a strategy really they're using?
Maybe not. In litigation, people use all kind of means. But it's quite interesting that you see those top lawyers. I'm sure many of them, it's been a while since they went to the magistrate court. Most of them go to the High Court. But the gravity of this is that this is the DCJ being brought to the magistrate court. And then the argument is that there was proper procedure that was supposed to be followed, which is in the Constitution, about any integrity issues that is brought on the case of an constitutional office holder like the DCJ. So there are quite a number of arguments that lawyers can make also, but lawyers never agree.
Yeah, okay. And I'm just going to read some of what the High Court Judge Chacha Mwita said, is that there's a significant constitutional question pertaining to commercial law that needs to be settled, as it needs to be clear whether Mwilu can be charged, that's DCJ Mwilu can be charged for failure by her lawyers to execute stamp duty. He has not addressed the other allegations in court, which was at the High Court, but he still issued the stay. And just in closing, what is your overall view about the fight on corruption and the fact that it has actually gone to some of the high and mighty? We are seeing some of the big fish, being arrested or facing charges or allegations from government institutions. What's your view on this?
My view is that if we talk about fighting corruption, one of the main things is about transparency. We need more transparency laws. We need to enact, as a country, more transparency within the public service. Second is that we need to address the issue about our big budget. We are having too many projects that we are having, and these projects are avenues for people to steal. If you want to fight corruption, one of the biggest and one of the easiest way is to have a very lean government. When you have a big government, you'll always have this problem. You will always be shuffling people in and out of court. The best way is cut them out of the cookie jar. So for me, I will advocate that as we move forward, in terms of budgetary process, Parliament should look at an option of having a small government. We need to reduce the kind of spending on government that we have on 3 arms of government, we need to spend that. We need to look at the kind of spending that we give out on this project.
That would mean a referendum.
No, not
pretty much in terms of if you're going to reduce the spending.
Yeah.
Would it be would the first thing top of mind be cut down the numbers, which has already been proposed by a number of people?
Yeah, there is. But if you talk about cutting numbers, you talk about Parliament. Parliament takes around 30. This budget that is coming up in this financial year, around 39 billion. Executive itself has 1.2 trillion, if I'm not wrong. So you look at who exactly is taking amount of money. You talk about the executive. The executive is part of Parliament that has the mandate of oversight. It's upon Parliament to trim down all the things that the Treasury asks for. You know, Treasury brings projects and everything, and Parliament always gives them that free will. You bring projects and we give you budgetary allocations, we give you loans, and we remove your debt ceilings and all that. Parliament needs to streamline the kind of projects that are coming up from the executive.
All right, thank you very much, Tony Watima, for speaking to us on this special edition of State of Corruption in our coverage of the same. And aside from this, we've got other news that's coming up in just a bit at the 1 o'clock bulletin, including news about some KDF soldiers who've died after an IED blast. And I shall give you the details on that and more. Thank you for staying with us. See you in not too long.